Good morning, sir. Are the picture and sound working as they should?
Yes.
Sir, just a reminder that we have a fire alarm at 10 o'clock. If you're content, then we'll just stay silent for that alarm.
Of course, yes.
Thank you, sir. May we please continue with Mr. Bowyer's evidence?
Yes.
Good morning, Mr. Bowyer. When we adjourned yesterday, I was coming to the Cartwright King review.
Excellent. I haven't got my statement in front of me.
Let's see if we can get that sorted.
That's perfect. Thank you very much.
Could we have on screen, please, paragraph 68 of Mr. Bowyer's statement? That's page 16. You describe the review process here in this way. You say, in broad terms, the process operated by the relevant files being subjected to a first sift. This was carried out by various solicitors at Cartwright King, including Martin Smith and Andrew Bolse, and those cases that passed the first sift criteria were subjected to a second sift, which was conducted by counsel. Initially, the only counsel involved were Simon Clark and myself, but later counsel from the independent bar were instructed. The operation was conducted from the Cartwright King Derby offices to give easy access to the files. If disclosure was required, we were advising Post Office Limited to disclose the second site interim report and the Helen Rose report. Just picking up on the last sentence there, that where disclosure was required, you were advising the Post Office to disclose both second site's interim report and the Helen Rose report. You may have seen from the papers that there are a number of cases on which you advised where your advice covered the interim second site report and advised that should be disclosed, but did not mention the Helen Rose report or advise its disclosure. So just taking an example, the case of Alison Henderson, that's the case you address at paragraph 82 of your statement. And the advice, if we can have it on screen, please, is POL 002 94503. You can see that's the case of Alison Henderson. And going, please, to page 3. Under discussion. If we can just give Mr. Bowyer a moment just to look as we scroll down that discussion section and then over the page to the conclusion. Can you see that the second site interim report is addressed and the advice is to disclose it, but there's no reference here to the Helen Rose report? Can you help with why in some cases only the second site interim report was being disclosed and not the Helen Rose report?
I'm afraid I can't recall on case-by-case basis.
Would there be any type of case where one but not the other would be disclosable?
I think there were. I think in some of Simon Clark's advices, he actually specifically disclosed one and not the other.
Could we have on screen, please, POL 001 98128? This is your advice in the case of Kathleen Crane, and you address this at paragraph 79 of your statement, if you want to see that.
Yes. This
was a Horizon Legacy case. And going to page 3, please. Paragraph 9. You say this is a pre-Horizon Online case. The second site interim report deals largely with Horizon Online. We have nothing to disclose that directly relates to the pre-Horizon Online cases. If this was a case where the allegation was one of theft or the defendant was sentenced on the basis that she had appropriated the money, the position might well have been different. To what extent if at all, did you consider that legacy horizon cases might attract disclosure of the second site report?
Well, I think we did disclose some of the legacy cases.
Well, we can come to that. I think you've quite recently seen a copy of your advice in the case of Peter Huxham. Is that right? Do you recall?
Yes, I would.
And if we can have that on screen, please. It's POL 0029 4518. We can see from the title here that this was also a pre-Horizon Online case. Your advice is the 4th of September 2014. And going to the discussion on page 3, paragraph 10, please. You say, this is an unexplained loss case where the defendant states that he was covering up losses that had occurred for reasons out with his knowledge. There is no danger of the defendant's conviction being found to be unsafe, as he has admitted his guilt from the very first, but he has been adamant that he did not take the money to the point of fighting and losing a Newton hearing. His explanations as to the possible loss relate to possible thefts, either by a member of staff or seemingly at the Newton hearing. His wife may well have been modified into an attack on the Horizon system had he but had the material to mount it. And then over the page, please, at 11. I doubt that an appeal against sentence will be mounted after any disclosure that we might make in this case, as the sentence has been long served. The reality is that the second site interim review deals in the main with Horizon Online, the system that superseded Mr. Huxham's system, but it did deal with the pre-Horizon Online issues, and in my view, had we had the material contained in the second site interim report at the time of the Newton hearing, we would have served it on the defence. And then the conclusion, those instructed by Mr. Huxham should be written to in order to make disclosure of the material contained in the second site interim report. So in this case, you advised the interim second site report was disclosable. Yeah. Can you help with why there was a different approach in this case to the pre-Horizon Online case, and whether there was any particular principle that was being applied at the time?
I can't help as to my thought processes at the time. It's 10 years ago.
But was there a common position among those at Cartwright King, initially you and Simon Clark, reviewing cases on whether the second site report and the Helen Rose report should be disclosed in Horizon legacy cases?
I don't think there was a position. We were disclosing it in some legacy cases.
Do you think there should have been a principled approach to that?
Well, looking back, I think that we should have had a common view. You have to remember that the review process was looked at twice by Brian Altman and found to be robust, both in his interim review and his other review. And he looked at some 31 of these these advices. So at the time, we thought we were doing it right. I can see that an awful lot of these documents, with what happened subsequently, because at this particular time, this was after the second site review came in and said that the system was robust. That they'd found no evidence of systemic failure in it. It was only when the civil case came up in 2019, when Mr. Justice Fraser found considerably more than we were aware at the time, that the totality of what Horizon was doing was actually made available to us. So at this particular time, we thought that what we were doing was right, and we were confirmed in that because our advices were being reviewed.
Thank you. That document can come down now. Thinking about another pre-Horizon Online case, we looked at some correspondence yesterday about the draft Gareth Jenkins statement, yes, and particularly the amendment that you made deleting the case-specific references that were in that statement, which included his involvement in the Seaman Misra case. Do you remember that?
I remember that, yes.
It was your view at the time that Mr. Jenkins' evidence could not be relied upon once the interim second sight report came out and
Yes.
Following that. Did you give any consideration to whether Seema Misra should be told in clear terms that the expert witness in her trial was, in your view, discredited?
Well, I didn't review Seema Misra's case, but I think my view would have been it should have been disclosed.
When you were reviewing the cases that you were, did you notice any patterns of sub-postmasters raising unexplained losses and challenges to Horizon?
No, I think I said in my statement, one of the problems was that the allegations against sub-postmasters were often very different. We had allegations of people taking money directly from the post office till, and there's one case where they were allegedly, according to one of the other witnesses, paying their staff directly from the sub-postmaster's bill. Other cases, we had people who pleaded guilty and admitted that they were paying off the retail side of their business from post office funds in the hope that they would repay it. We had other cases where people were actually, when people wanted to withdraw money, they were typing in their PIN numbers, and it would fail first of all, and then they would type it in again and get the funds. And the allegation was that the first one would be pocketed by the sub-postmaster. So we were dealing with a whole different type of offending. And so, yes, there were cases where people were alleged to be short on their funds, but there were other types of offending as well. And so what we were looking at didn't fit a single Horizon bug. Now, obviously now we know that there are several types of Horizon bug, but that simply wasn't our state of knowledge at the time when we were reviewing it. And the second sight report came in and said there was nothing systemic.
Is it right that you would occasionally attend the weekly hub meetings, later bi-weekly meetings on behalf of Cartwright King?
Very occasionally. I would do it when either Andrew Bowles or Martin Smith weren't available.
And roughly how many times did you attend? Can you recall?
I'd imagine you could count it on one hand.
Did you ever hear of any issues raised at those meetings that you thought required post-conviction disclosure or further disclosure review?
I don't think so, no.
Could we have on screen, please, paragraph 108 of Mr. Bowyer's statement, please? That's page 31. Apologies if I've given the wrong page reference there.
Paragraph 108 is page 23.
Yes, thank you, sir. My apologies. Bear with me for just a moment. It's page 31. It's paragraph 155, please. You say here, the reality is that there may be grounds to criticise the way that Cartwright King conducted the Post Office Limited prosecutions. However, they did fulfil their role as external lawyers in calling to a halt the prosecutions.
Attention, please. Attention, please. system has now been completed.
Just rereading that sentence, and that
Yes.
first sentence, the reality is that there may be grounds to criticise the way that Cartwright King conducted the Post Office Limited prosecutions. Did you recognise at the time the Cartwright King review was set up that there may be grounds to criticise the way that Cartwright King conducted Post Office prosecutions?
Yes, I think when I was reviewing cases and when I was actually speaking to the people more involved, it became apparent as to how it was being done. And yes, I had concerns.
And at what point into the process did you have concerns?
Really, during the review, the SIF process, when we were reviewing cases. You have to remember, we were reviewing a lot of cases that weren't Cartwright King. They went back quite a long time.
At the time, did you recognise the risks inherent in Cartwright King, and this phrase has been used a number of times, marking its own homework?
Well, yes, because that was addressed at a very early point. Especially, we had a conference with Brian Altman in his chambers in September, I think, 2013. And that point was addressed there and then. But I think it was felt that, A, the Cartwright King barristers actually hadn't prosecuted the cases themselves, and B, this was the fastest way of getting the job done.
That statement can come down now, thank you. I'd like to ask you next, please, about what happened in relation to cases in Scotland and Northern Ireland after the publication of the Second Sight interim report. Can you help with what was done by the Post Office or by Cartwright King, if anything, to inform the Crown Office and Procurator Fiscal Service in Scotland and the Public Prosecution Service in Northern Ireland that Second Sight had been instructed to conduct their review in 2012?
I can't know.
There are documents the inquiry has to suggest that Martin Smith from Cartwright King was involved in discussions with the Crown Office and Procurator Fiscal Service and BTO solicitors, to whom
Yes.
you referred yesterday, about the interim Second Sight report towards the end of July 2013.
Yes.
There are also documents to suggest that Simon Clark and Martin Smith attended meetings with BTO solicitors and the Crown Office and Procurator Fiscal Service about Horizon in September 2013. Did you have any involvement in those discussions?
No, I had no involvement in those discussions. And they did certainly at least one trip, possibly more, to Scotland and BTO. I did speak to BTO on a couple of things. I think there's some email correspondence between me and one of their solicitors. But I didn't actually have any direct influence on the Scottish prosecutions.
Was there any consideration given to the impact of the interim Second Sight report on disclosure duties on prosecutors in Scotland and Northern Ireland? Specific review and process of a similar review exercise taking place in Scotland or Northern Ireland?
I wasn't.
Does it follow from your answers that you can't help with whether Cartwright King notified the Crown Office and Procurator Fiscal Service or the Public Prosecution Service in Northern Ireland of its review exercise?
I don't know.
In 2014, 333-520. This is an email chain which you're not part of, but we see your involvement in the case is referred to in this top email from John L. Singh, dated the 8th of October 2014. And before we look at that, just to put this in context and look at some of one of the earlier emails, If we can look at page 2, please. About 2/3 of the way down the page, there is an email dated the 19th of September 2014 from David Oliver to Chris Ojard, copied to John L. Singh, among others. And it says this, subject Duran case. Chris, I wanted to bring one non-scheme case to your attention and check you are content with the suggested approach. The case in question relates to Mrs. Duran, deceased. The case was one of the original cases raised by MPs but did not apply for the scheme. It is an old case, 2004, and relates to an unsuccessful prosecution brought by the police in Scotland. Mr. Duran has written to Paula raising this case and criticising the Post Office's handling of it, and his MP has, with James Arbuthnot, sought a meeting with Paula to discuss the case, which James is chasing a response on. The case has been looked into by the Crown Office in Scotland, and Post Office has been in contact with them via BTO. John L. has previously dealt with this. Last correspondence I've been able to find internally, 14th of April. Then there's proposed next steps. And we can see over the page, John L. to contact BTO for any further and more recent correspondence. Subject to that, contact Crown Office to understand their views on the case and what has been provided to Mr. Duran. I will draft a holding reply to go to James. So that sets out some of the background to the case. Does this help refresh your memory at all as to how cases in Scotland were being looked at or reviewed, the references in that email?
No, I'm afraid it doesn't. I had very little contact with Scotland.
Going then to page 1, John L. Singh's email of the 8th of October 2014. He says, Belinda and Angela, as you know, Counsel Harry Bowyer of Cartwright King reviewed the information which Scottish police were able to provide in this case. It would appear this was limited and most probably not all the information that was provided to the Procurator Fiscal. This was not a poll investigation. However, if it is now to be investigated under BAU, it is my view and advice that any findings and further evidence discovered should be supplied to Harry Bowyer in order that he may review it. This would ensure Poll has the protection of being able to say the findings have been independently considered by external senior barrister. Was this common, John L. Singh asking you to take a look at individual cases?
There would be occasions. There would be occasions he'd ask me to look at cases. There'd be occasions he would ask me for advice on little issues. Yes.
And this appears to be on a sort of ad hoc basis
Very
rather
much
than
so.
as part of the review process. Is that right?
Yes. I mean, we got contacted if they had questions outside the review question process.
Was it common for you to be asked to look at Scottish cases?
Well, not terribly, because of course Scottish law is different, and I'm not qualified.
Did you feel able to advise on this Scottish case?
I don't recall this Scottish case, but the email suggests that the information was limited.
Were you aware that John L. Singh saw the purpose of asking you to look at cases in this way as being that the Post Office would have the protection of being able to say it had been reviewed by an external senior barrister?
I wasn't aware, but I would have been able to guess at it, yes.
That can come down now, thank you. At paragraph 106 of your statement, you refer to Cartwright King's involvement in drafting a new prosecution policy for the Post Office. Recognising that you say you had little to do with that side of things, what was your understanding of the policy in terms of its geographical remit, particularly thinking about Scotland and Northern Ireland?
I would have assumed that Simon would have been drafting it for England and Wales.
Can you help at all with whether the procedure in Scotland and Northern Ireland was viewed in the context of possible reform of Post Office Limited's prosecution policy? Was it considered at all?
Well, I don't think I had any role in that particular review process.
Could we have on screen, please, POL 00333 527? The top two emails here are from April 2015 and are between you and Laura Irvin, who was a solicitor with BTO Solicitors in Scotland, the external firm who advised on post office cases. It appears from your email to, just scrolling down a little, please. Your email there, Laura at the top, Harry Bowyer at the bottom. It appears from this that you were looking after Martin Smith's emails whilst he was on holiday, and that was why you were in email correspondence with her. Is that right?
That would be right, Miss.
And starting with Miss Irvin's email of the 26th of March 2015, please, at the bottom of the page. Her email to Martin Smith. She discusses a Scottish case and appears to be trying to establish what the progress was on a Horizon expert report. Is this a reference to the attempts which were being made to find another expert
Yes,
at the
I
time?
think so.
And then at the penultimate paragraph of her email, she says, I have been provided with various pieces of information about the progress with the Horizon expert report, mostly by you, but that the last I heard from John Scott was that there was a report from Deloitte that may negate the need for an expert report. However, I got the impression from you yesterday that it didn't tick all the boxes. It would appear from this that BTO solicitors had not been provided with the 2014 Deloitte report. Would you agree on a reading?
Well, it looks like it, yes.
Your reply is above. And you say, Laura, Martin has me looking after the emails. The Deloitte report does not tick all the boxes, and we would prefer to be given a clean bill by the experts who are in the process of being instructed. They will be in no position to report in the timescale of this case. 2 points arising from this, please. First, you don't mention here your reaction of shock to the revelations in the Deloitte report about remote access, do you?
No.
Can you help with whether that issue of remote access was raised with BTO solicitors following Cartwright King's receipt of the Deloitte report?
I don't know, because the main contact between BTO was Martin, and you can see from this email, I was only stepping in while he was on holiday.
Second, you appear to be suggesting that any expert report would be giving Horizon a clean bill of health. Was that your view at the time?
Well, that's what we thought was going to happen, yes.
Why were you so sure of that?
Well, again, it was the second site report with no systemic problems. And so as far as their report was concerned, we thought we would get an expert report that would show that it was fundamentally sound and the evidence could be relied on. If the expert report had come back and said it couldn't be relied on, then that would have been the end of prosecuting.
That can come down now, thank you. In an email chain we looked at yesterday from August 2012, you referred to cases raising Horizon issues being likely to become more numerous as the bandwagon picks up speed. Why did you use that expression, bandwagon?
Yes, I think the inquiry is attaching pejorative terms to it. There are popular themes in criminal law and popular defences that arise. There have been bandwagons that I've joined when I've seen that a defence seems to be working. I will leap upon it. But no, as far as this was concerned, when Horizon became an object that looked as though it was being challenged, more and more people would actually take a look at it when they got a post office case in. It's common sense. But I don't see that the phrase bandwagon is in itself pejorative.
We needn't go to the documents unless you wish to, but bandwagon was an expression which was used by you in two advices relating to post office prosecutions, given after the publication of the interim second site report. You referred yesterday to the interim second sight report being a shock moment.
Yes.
Did it not therefore make you more wary about making the kind of assumptions which underpin the use of the language horizon bandwagon?
I don't think so, no, because you can join a bandwagon that is perfectly proper. There are occasions when the reason people are all heading in the same direction is that they've got a valid cause. But as I said, I don't find the term bandwagon pejorative.
There is one further document from yesterday I'd like to go back to briefly, please, for a point of clarification. The reference is POL 00293276. This is the 13th of January 2020 letter about continuing the relationship between Cartwright King and Post Office Limited. Going to page 2, please. What we looked at yesterday was that point 3 with reflections on past setup and relationship. But just looking down a little to the proposal here, the proposal being made in January 2020 was that Cartwright King would provide Post Office Limited with, there's a number of things listed there, but at point 4, the designated on-call lawyer shall be Simon Clark, Martin Smith or Harry Bowyer, but most likely Simon Clark. Can you help with why, after you left Cartwright King, some 4 years afterwards, you were being put forward as a potential on-call lawyer?
I wasn't sure as to what was going on here. What happened after we left was effectively we took the Post Office Department, myself, Martin and Simon. And so Andy Cash used to continue to call us up to see what was going on. And Post Office wanted this facility. By this stage, we weren't terribly keen on doing it because, of course, we'd had the civil case and seen Mr. Justice Fraser's judgments in the two issues that he decided.
Did this proposal come to fruition?
No.
That can come down now, thank you. Just one final point from me. You've said in your statement at paragraph 65 that the Post Office was an enormous client, even for a firm the size of Cartwright King. As you sit here today, do you think that the importance of Post Office as a client to Cartwright King influenced, whether consciously or subconsciously, the way you approached your advice and your ability to advise impartially and independently?
Yes, I think it must have. When we actually pulled the plug on the prosecutions after the Clark advice, it was worrying as to how our bosses at Cartwright King would take it. And it was, it was a big moment telling Post Office that they could not rely on their expert and they should stop prosecuting.
So those are all the questions that I have. There are some questions from core participants. Those I know about are Mr. Henry, Mr. Maloney and Ms. Oliver. There may be, and Mr. Jacob as well. And I think that's it. In terms of order, if we can start with Mr. Henry, please, sir, then Mr. Jacob, then Mr. Maloney, and then Ms. Oliver. Is that
Certainly.
acceptable to you?
Yes, of course.
Thank you, sir.
Mr. Bowyer, so in a nutshell, you weren't happy with Mr. Jenkins's independence, so you decided to draft a generic pro-prosecution template for him.
No, that's not true.
Well, you were trying, you said, to be fair to the defence, and just coming to an expression that you used yesterday, that this statement would give the defence a windmill to tilt at. tilting at windmills in contemporary parlance, Mr. Bowyer, is typically understood as attacking imaginary enemies or evils. Is that what you thought the defence were doing, that Horizon was impregnable and that their complaints were imaginary?
Well, at the time, we thought, and our instructions were, that Horizon was robust.
So is the answer to my question yes?
No, the answer to your question is, as far as the statement was concerned, it was meant to give something that the defence could, A, take a look at, the previous cases where the challenges were put in, so that they actually had somewhere to go, so they didn't have to start from scratch. Your question is unfair.
No, it's not unfair. It's entirely fair because you use the expression tilting at windmills, and I suggest that it reflects your overconfident, if I can put it neutrally, your overconfident approach to the issue.
No. Well, we disagree.
That the defence were on some sort of quixotic, unrealistic and ineffectual exercise of challenging, how dare they, the Horizon system.
Well, as I said, the idea was to actually give them an opportunity to make something of it. At the time, we had nothing to suggest that the Horizon system had any faults to it. Now, I can understand where you're coming from, because you're looking at this from 2024.
Don't presume to understand anything from my point of view, Mr. Berrier. Let's go on to a document which is POL 000-96997. No need to get it up. You'll remember it. It was put to you yesterday. But you refer to defence inquiries as a fishing expedition. Did that reflect your view about defence requests for disclosure in relation to Horizon?
Some of them, certainly.
And your prediction, 2nd of October 2012, my view is that most challenges to the Horizon system should now vanish away before the trial. Were you taking, Mr. Bowyer, effectively a blinkered approach?
And I can see that particular comment hasn't aged well, but no, I don't think so.
Right. Can we turn, please, to POL 000-66807, please? This is your response to Mr. Altman's review. And could we go to page 3 of this document? And let's concentrate on Roman 7. Whilst this system is still in its infancy, there are issues that should be dealt with as soon as possible. A, an expert to replace Gareth Jenkins must be identified and instructed without delay, as almost all of our cases depend on the integrity of Horizon, even if only to the quantum of thefts. We need to have an expert to say that the system is sound, and whilst there are and have been glitches, the system and its product are sound. Does that not show that the intention was not for the expert to be objective, but rather to reach the conclusion instructed by Cartwright King?
Well, no, I don't think so.
We need to have an expert to say that the system is sound and that whilst there are and have been glitches, the system and its product are sound. Time is of the essence, as there are cases in the system that will be compromised without such evidence. This is old ground, so I will not go over it again. And this was essentially, was it not, the idea that the expert inevitably would say that the system was robust. A dangerous assumption on your part, Mr. Bowyer.
Well, if the expert said the system wasn't robust, it would have created problems for us, and we would have ceased to prosecute. But at the time, our instructions were that it was robust, and Second Sight had found nothing systemic.
But they had found disturbing issues concerning 2 bugs and also other deficiencies in the way in which the postmaster's complaints have been dealt with. Could we go to subparagraph B? The product of the hub meetings should be collated and assessed. Much of it is raw rumour, but it needs to be investigated so that we can dismiss it as that. Again, does this not reveal raw rumour investigated so that we can dismiss it? Does this not reveal institutional bias on your part, too close an alignment with your professional and lay client?
Well, I don't think it does, no.
Other material may well point to genuine flaws in either the Horizon system or the use of it by post office staff, and needs to be addressed both to fix the flaws and be assessed as to its potential disclosability. How could flaws in the Horizon system, genuine flaws, be only regarded by you as potentially disclosable?
Well, again, this particular paragraph shows that I'm looking at the disclosability.
Don't you think that it ought to have been slightly more emphatic, or would that not have been unpalatable to the client? If there are genuine flaws, they must be disclosed.
Yes, you would be right.
Right. So were you trying to sugar the pill?
No, I'm afraid if you point at clumsy English, it doesn't mean that my intent was to actually make things palatable to the lay client.
Miss Price has taken you today to a Scottish case where you were trusted by John Isle Singh to review it. The case was called Doran. She faced embezzlement charges of over £7,000 and was acquitted. And she said all she'd done was to follow instructions on the screen. In other words, she was not dishonest. She was only following the instructions that Horizon had given her. Do you remember the case now?
I don't remember it, no.
Well, I don't want to ambush you, but it seems you advised on non-disclosure.
You may well be right. I take it from you.
Let me just ask you now to in the mediation scheme and disclosure issues, do you accept that quite a lot, and the document I'm going to take you to doesn't actually refer to this, but a number of the issues in the mediation scheme, a substantial minority of these applications contain complaints about the behaviour of post office investigators?
Yes.
And you were against the reports that those investigators had compiled being disclosed, weren't you?
I was against some of the working documents being disclosed, yes.
Right. Well, let's go to POL 00301427.
While that's being brought up, just so that I can clear my mind, the actual criminal Doran case was long before your involvement, as I understand it, and you became involved because of the potential review of that case in the mediation scheme. Is that correct?
I think so. It was a Scottish case. I've got no recollection of it.
No, I appreciate that, but given that your involvement was, I think, 2014,
yes,
and the actual case was about 10 years before,
yeah,
it seems to be the only logical explanation.
Well, I'm not sure whether it's for the mediation scheme or whether for some sort of Scottish review. I don't know what it's
All
for.
right, so it's either the mediation or some review occurring in Scotland.
Yes.
Fine, all right.
Thank you, sir. While that's been brought up on the screen, POL 00301427, but the fact that somebody was being tried on Horizon data, the case was brought on Horizon data, the charge was dishonesty, and they had been acquitted. Did that not strike you as disclosable in other cases?
I don't think I considered it. I don't know.
Right. can we go to your email in this email chain, please? And we start off with, I agree with Harry's advice. Can we scroll down, please? And can we scroll further down, please? And then we have that. Yes, Roman 2, please. This is your advice. The views of the prosecuting lawyers at an early stage of the proceedings on the strengths, weaknesses of our case being exposed to defendants and their defence teams. These were your concerns, and that was the concern that I've just read out. This could create problems should we recommence prosecutions. In extreme instances, we could become witnesses in our own cases. An obvious example is the case of Chowdhury, Wasim Abbas, in which neither the Post Office investigators nor the poll systems cover themselves in glory. I'm sure that our mutual client, POL, does not want a document in the public domain that provides a route map to how to attack us where we are most sensitive. Ms. Boyer, isn't that precisely the purpose of disclosure under the CPIA, that the material might be capable of undermining the prosecution case or assisting the defence?
Absolutely.
Right. So why did you say, I'm sure that our mutual client does not want a document in the public domain that provides a route map to how to attack us where we're most sensitive?
Because as far as that's concerned, it should be considered in the context of each case.
Right. And can I just ask you to consider this? The Horizon bandwagon, and you say that that wasn't pejorative, and so be it, but those two advices that Ms. Price referred you to were dated the 2nd of September 2013 and the 5th of September 2013. Here we are involved in the mediation scheme. Do these views not reveal a somewhat jaundiced approach which might have affected the way in which you were performing the SIFT?
I don't think so, no.
Well, my conclusion are two matters. The first is, and they're both concerning clients represented by Messrs. Hodge, Jones and Allen, who instruct me. One is Mrs. Kathleen Crane. You reviewed her case in November 2013, and you stated, in my opinion, and we need take no further action upon this file. And so, therefore, the safety of her conviction was not reviewed as a result of that advice, and she was only cleared in the Court of Appeal in January of this year, having suffered years of anxiety, having, of course, lost her occupation and having to go into a caring profession where she was having to disclose her conviction, of course, to the Disclosure and Barring Service with every employment application. Have you read the judgment in her case?
I'm not sure that I have.
The Court of Appeal stated at paragraph 22 that they were satisfied that the Post Office was correct in conceding the matter, and they continued to state, this is indeed a Horizon case in which the reliability of Horizon data was essential to the prosecution, and there was no independent evidence of the alleged or any actual loss. And then they continue, the applicant in interview explained why she had acted as she did and asked for the reliability of Horizon to be investigated. She and her husband paid the full sum said to be missing. She was nonetheless prosecuted. No relevant investigation was carried out and no disclosure was made of the known concerns about Horizon. Mr. Bayer, how on earth did you come to the conclusion that no disclosure was merited in her case?
I'm afraid I don't know.
Mrs. Misra's case, which you were aware of, but of course was dealt with, I think, by your colleague Simon Clark.
He was, yeah.
She needed to be told in the clearest terms, you would agree, that the expert witness in her trial was discredited. You would agree with that?
I would agree with that.
And yet that didn't happen, and she wasn't even given what I suggest would have been the inadequate disclosure of merely the Second Sight report or the Helen Rose report. Now, I realise it wasn't your case, Mr. Bowyer, but you were part of the team.
Mr. Henry, I think he has said it should have been disclosed. That's good enough for me.
Thank you, sir. Those are my questions.
Thank you. I think we have Mr. Jacob next, is it?
Thank you, sir. Yes, Mr. Bowyer, I want to ask you some questions about the mediation scheme.
Okay.
And you've set out in your witness statement at paragraphs 109 through to 140 your involvement in the Cartwright King reviews of the mediation responses. Perhaps we don't need to go to this, but one of your responses in the case of Walters, who was one of our clients, at paragraph 117 of your statement, the response is, dangers to Post Office Limited. This case did not result in a prosecution or a conviction. It is unlikely to affect any criminal cases conducted by Poll, past, present or future, unless some concession is made about the integrity of Horizon, which from the robust Poll response seems unlikely. Do you accept that it was Cartwright King's position to ensure that nothing came out of the mediations that could result in damage to Post Office's position that the Horizon system was a robust system, or could lead sub-postmasters to have any evidence upon which they could cast doubt on the integrity of the Horizon system?
Well, as far as we were concerned, obviously you've seen from the papers that my position was we didn't want criminal defendants in there. But yes, I mean, as far as we didn't want unwarranted concessions to be made, that the Horizon system may have been may have not been robust, because that was not what the evidence actually said at the time. I concede totally from our point of view, looking at it from 2024, that has not aged well.
Well, exactly. And in July 2012, you wrote your advice in the case of Wiley.
Yes.
Where effectively you said that Post Office was in a firefighting situation.
Yes.
Fujitsu should consider themselves also to be in that position.
Yes.
And that, to summarise, there would be severe recriminations for the business if Second Sight uncovered any systemic problems. Is that right?
Yes.
So what you were saying is, don't do anything that could result in a concession being made that Horizon is not robust.
I can see how you're formulating the question, but the intent was I didn't want any unwarranted concessions made that the system wasn't robust.
And what's an unwarranted concession?
A concession merely to make the mediation go more smoothly.
Right. Are you aware, and I'll give an example of a case of one of our clients, Mr. Peter Holloway. He attended a mediation in November 2015. Presented his case to the Post Office representatives with the mediator present. He says the mediator told him there was a good chance that the Post Office would agree to settle his case and that there might be a reasonably significant sum. Post Office representatives thought about it. The mediator returned to Mr. Holloway at 3 o'clock in the afternoon and said, "I don't know what to say. They're refusing to even make you an offer." The mediator told Mr. Holloway that the Post Office representatives had told him they'd been sent to the mediation with instructions not to settle at all. Were you aware that Post Office representatives were attending mediations with instructions to maintain in the mediation that Horizon was robust and that there should be no settlement, or if any settlement was made, it was simply to be a token?
I wasn't aware, no.
Are you aware that anybody in Cartwright King advised that what you had advised in relation to the Wiley case should feed through into the conduct of the mediations?
Again, my main role was to advise on various documents that were going forward to the mediation. How the mediations were carried out, we had no role in.
You understand, of course, that the the function of mediation is that there should be some concession.
No, I totally understand that, and to an extent that's part of the danger.
Can I then move on to another topic? I want to ask you about Brian Altman, KC, and his terms of reference, and we will need to put a document on the screen for that. It's POL 000-21981. Just wait for it to come up. So here we have Mr. Altman's observations on his terms of reference for making a presentation in relation to the Post Office Board. Can we scroll down, please? And can we scroll down to B? So scroll down further. Right. So B, I understand that I'm to meet and report to the board. And then if we move to scroll down further. So point 2, on the efficacy of past prosecutions, including the preparation and conduct of past prosecutions. And then if we move down to footnote 4 at the bottom of page 3, please. And if we could maybe highlight, we've lost it. Footnote 4, bottom of page 3. Thank you. So Mr. Altman says, it is for Poll and those instructing me to determine whether or not it is only the efficacy, i.e. effectiveness of past prosecutions, etc., that I'm being asked to consider with the board, or in fact the potential safety of past convictions following Poll prosecutions, i.e. whether in my judgment the Court of Appeal is likely to think that the conviction is unsafe. Now this follows on quite shortly from Simon Clarke's advice, where he said that Gareth Jenkins, the architect or one of the architects of the Horizon system, his evidence was tainted and unreliable. Did you think at this point that senior counsel ought to be advising on the safety of the convictions in light of the apocalyptic revelations concerning Mr. Jenkins?
Well, as far as the convictions were concerned, most of the convictions were guilty pleas, and
Sorry, I didn't hear you. I didn't.
Most were based on guilty pleas, and most had admissions in interview to some sort of false accounting or whatever, and the position at the time was, as I said, Second Sight came back and they said that there were no systemic faults in Horizon. They produced the 2 bugs that they produced. And so when we stopped the prosecutions, it wasn't on the basis that Horizon was unsafe, because we didn't know that it was unsafe. We felt that nothing systemic had been found on it. We stopped it because we felt that the witness Gareth Jenkins was unreliable. And so the catastrophic findings later that Horizon had multiple bugs in it only really came to light in 2019 in the civil case in front of Mr. Justice Fraser. And certainly at this particular stage, as you know, a guilty plea is a very difficult thing to appeal in the Court of Appeal. This case, of course, it happened because these cases were, and I don't dispute it at all, these cases were an affront to justice because people had false accounted because they were met with massive figures.
What about, if it can be inferred, surely it must be inferred from the Gareth Jenkins position, that there had been multiple failures of disclosure in numerous prosecutions over the years?
Well, there had been failures of disclosure.
I'm sorry to intervene, but this started as a question about Mr. Altman's terms of reference.
All right.
With respect, Mr. Jacobs, I don't think Mr. Bowyer is the person to ask about that. Mr. Altman was instructed, I believe, by Womble, Bond, Dickinson, or whoever, and very much having an input from senior post office lawyers. I don't think Mr. Bowyer was involved in his instruction.
Of
And
course.
if he was, I apologise, but I don't think he was.
I'll move on to the next document, which is POL 000. Sorry, POL 00. Zero 21980. This is in relation to the efficacy point, and I just want your comment on this. And I know that, that this isn't an email that you saw at the time, but this is Womble Bond Dickinson responding to Mr. Altman's footnote. And what is said here is, please find attached two separate terms of reference for Brian Altman QC as amended in response to his observations document, which I also attach for ease of reference. Please note that Paul needs to decide on the issue which is asked to report to the board on the efficacy or safety of past prosecutions. See footnote 4, page 3, which you've just gone to, of Brian's observations. Simon's and my view is that he shouldn't report on the safety of past convictions for two reasons. Firstly, this is likely to involve a more significant analysis of lots of cases, thereby delaying his report. And secondly, and potentially blurs the boundary between BA and CK's respective roles. Now, you've said in your evidence that you thought that Bond Dickinson's knowledge of the criminal law was somewhat sketchy. Is that right?
That was my opinion at the time.
What do you have to say about the advice that Bond Dickinson were giving Post Office in relation to Brian Altman's query about whether he should be advising on safety?
Sorry, what was my opinion then on that?
Yeah.
I wasn't aware that he was being instructed at the time, or they were considering him looking at the safety of the reviews. Our instructions in the SIF review was not to look at the possible, look at the potential of appeals at the time. It was just as to whether the stuff would be disclosable or not.
And do you think, following the Simon Clark advice, that Post Office, in light of the potential for miscarriages of justice, ought to have sought advice on the safety of convictions as a matter of urgency?
I'm sorry, Miss. I just don't think this is appropriate for this witness. These questions can be asked of the people who instructed Mr. Altman.
Thank you, sir. I'll move on. I don't have any further.
Sorry, no, mate. Mr. Maloney.
Hang on.
It's on. Yep, thank you. I'm grateful to the stenographer. Mr. Bowyer, I'm going to ask you about Jillian Howard. She's one of the 78 core participants I represent, all of whom were prosecuted and convicted, and all of whom had their convictions quashed. And I'm going to ask you about disclosure in her case and why you didn't advise disclosure on review, but I'll take you to your advice in doing so that you can see why you didn't disclose, which will hopefully help when you're answering questions. Okay.
Yeah.
Now, she falls into the category of most cases that you've just described to Mr. Jacobs, that is to say, a guilty plea and an admission to false accounting.
Yes.
She was interviewed under caution on the 8th of June 2010, following an audit that revealed a shortfall of some just shy of £46,000. And then, so that's the 8th of June 2010 for the interview, and then by letter to Post Office on the 7th of April 2011, and that date is important, Mrs. Howard offered a guilty plea on a proposed agreed basis. Does this jog your memory?
I remember the case. I discussed it in paragraph 75.
I'll shortly take you to your advice, but just to finish the background details, as it were, to start with. She pleaded guilty on the 26th of April 2011, having indicated or offered the agreed basis of plea on the 7th of April of 2011. And on the 26th of May, she was sentenced to a 6-month community sentence.
Yes.
Just for completeness, at the Court of Appeal, Post Office accepted it was an unexplained shortfall case. Evidence from Horizon was essential to Mrs. Howard's case. No ARQ data was obtained at the time of the criminal proceedings. No evidence to corroborate the Horizon evidence. No investigation into the matters raised by Mrs. Howard in interview, and no examination of the numerous calls that she'd made to the helpline. In fact, she'd made 22 calls to the helpline saying that she was having real trouble balancing with Horizon, and none of the other staff at the branch was interviewed. And there was no proof of an actual loss. So a paradigm Horizon case in many respects.
No, I accept that. Indeed.
So could I ask that we look at your advice now, which is poll 30-21207. I'm grateful. And if we could go straight to the end, to paragraph 27. And there we go, thank you. Where you say, in conclusion in relation to this case, Mr. Bowyer, this is an extremely worrying case. It's only through good fortune, sensible prosecution counsel and a sympathetic judge that we are not going to have to disclose material which would cause Post Office Limited a great deal of embarrassment. Could we please go back up the page now to look at the specific circumstances of this case, and I think back to paragraph 15. So, and yes, and above that, please, if you could go back to the previous page. I'm sorry. Keep going. And and just slightly further, please. Going up, and going up, and there we go. Paragraph 10. Thank you. So. Paragraph 10 relates how Mrs. Howard, following the audit, said she'd like to arrange a PACE interview. She was told of her rights. She produced a typed statement and article from the Grocer magazine relating to glitches in the Horizon system. And her prepared statement and note also complained of lack of support from Post Office and says that a series of errors were made. Inference being she wasn't properly trained, but the contents of her interview are in the next paragraph. She's interviewed on the 8th of June, read out a prepared statement, said she'd not taken any money. She used to help her husband with the cashing up. She'd experienced problems in 2008 after her husband was taken ill. She employed 2 staff. When her husband was ill, she struggled to balance the accounts from the outset. She was never sure that she was completing the monthly balance correctly and simply put in the figures that Horizon displayed to balance. She was aware that the figures she was entering were inflated and that losses were increasing, and to hide the mounting shortages, she began to suppress business deposits from a local bus company. Carrying on down, she felt that an employee might be responsible for the losses. I won't name the employee for obvious reasons.
Of course.
She was concerned about her employee's sons visiting the shops to borrow money. She had less than a week's notice about the transfer to Horizon Online. Finally, she was aware that what she was doing was dishonest and had not financially benefited from any of the missing money. So she expressed concerns about Horizon as the Court of Appeal noted. If we could then go down to paragraph 13, which is just further down, you find other considerations. It became apparent, and this is an email from Helen Dickinson dated the 10th of February 2011, and that date's important because it's some 2 months before she enters her plea in April 2011. After Mr. and Mrs. Howard were suspended, that those who ran New Mill Post Office continued to employ the employee and also took on one of her sons. The Post Office continued to suffer small, unexplained losses, including cash being taken from a charity box in the secure area. It transpired that the employee had a key to the secure area that the new management were unaware of, and the employee's son has admitted theft from the charity box. And essentially what happened to that information, that it was kept under review, it wasn't disclosed, and there's a green post-it note attached to an email of 5th of April 2011 talking about scrapping the sensitive, unused items. If we could go down further to paragraph 18, please, the culmination of all of this is item 17 on the non-sensitive unused schedule dated 4th of April 2011, served on the defence by letter on the 11th of April 2011, so that's 4 days after the indication of the offer of an agreed basis of plea, when in fact this information was available some 2 months before the agreed basis of plea. There is an entry that reads, email from New Rolls personnel regarding incident at New Mill. Now that's the email that refers to the thefts by the employee's son, but it's really quite a cryptic reference, isn't it?
Yes.
For anybody looking at an unused schedule in those circumstances. So Mrs. Howard had pleaded guilty, but she said in interview that she always felt she wasn't completing the monthly balance correctly. She'd inflate the figures to make them balance. She brought an extract from the grocer, which made her wonder if she was wholly responsible for the shortfall problems, and money was going missing from the tills, which could have been another employee, or her giving credit, which she should not have given, was in fact what she said. We know that, in fact, that information about the employee's son was available 2 months before the agreed basis of plea was offered, and the schedule reference in April, just in fact after the agreed basis of plea was offered, was quite cryptic. So, after that, which Mrs. Howard had said in interview, should the material about the employee's son not have been disclosed straight away, as soon as it came to light, 2 months before any offer of plea?
Yes, I think it should have.
The disclosure reasonably assisted Mrs. Howard's case in interview and supported her veracity.
No, as I say in my statement, I think I got this particular advice badly wrong.
Thank you, Mr. Bowyer. Indeed, you do say that in your statement, don't you, at paragraph 75,
Yeah.
that, and I was going to go on to that, but just before we get to that, she was entitled to know that that information when she was considering her plea and when she was being advised by her lawyers as to her plea, wasn't she?
You're absolutely right.
Yeah. And it should have been disclosed on consideration of the appeal as well, shouldn't it?
It should have been, yes.
Because it would have provided a basis for arguing that there was serious material non-disclosure.
Well, over and above the Horizon system, yes.
Absolutely.
Yes.
Now, but you took the view that it's my view that there could not possibly be an appeal against conviction based on the disclosure of the subsequent losses in the post office, bearing in mind the admissions in interview and the basis of plea.
Yes.
But that was for her to decide rather than you, really.
As I said, I think I got this advice wrong.
Thank you, Mr. Bowyer. And also, can I just ask you about the information about continuing unexplained small losses?
Yes.
Because they didn't stop at what the employee's son was doing, did they? They were unexplained small losses,
Yeah.
which were not, as it were, only the theft by the employee's son.
I can't recall the details of the case that far, but I'm sure you're right if you say so.
But if we can assume for these purposes that in fact they were unexplained small losses, then they also would have assisted her case in interview, wouldn't they?
Again, I would have thought so.
Yeah, and really that should have been disclosed if they were unexplained small losses.
Yes.
And indeed, second sight report might well have been disclosed in those circumstances, given that it had, as it were, highlighted the difficulties.
As I've told you, and as I said in my statement, I didn't get this one right.
Can I ask you this? And it's important that I do ask you.
Yes.
Was this material not disclosed because, in fact, yes, it really would cause Post Office a great deal of embarrassment at a time when Post Office was already suffering a great deal of embarrassment?
I don't think so, no.
When you say you don't think so,
No.
was it a fact, either, I don't think a subconscious factor can operate.
Well, it may have been subconscious, but I mean, I like to think I'm a straight edge as a prosecutor. And, as I said, what overbore my mind in this particular one is that she was sentenced on her own basis, that there was, she wasn't responsible for the loss and so therefore she was sentenced on her pleas, her admissions in interview and her guilty pleas.
Yeah. But this material, as you rightly concede now, should have been disclosed.
I certainly concede, yes.
And finally, just to expand slightly on a point Miss Price asked at the end of her questions for you. You were asked about the importance of the post office account to Cartwright King.
Yes.
Yeah. You said yesterday that you were pleasantly surprised when Cartwright King management did not push back on your attempts to rectify the position following the revelations about Gareth Jenkins.
Yes.
And even because you said even for a firm of the size of Cartwright King, post office was an important account.
It was an important account, yes.
One of the central aspects of that importance, would it have been the amount of income the account generated for the management of Cartwright King?
It generated quite an income, yes.
Yeah. And that's an important consideration in these circumstances.
Oh, I would have thought so, yes.
Yeah. Thank you very much, Mr. Bowyer.
Mr. Bowyer, can you remember whether, notwithstanding someone had pleaded guilty to false accounting, you nonetheless decided that the second site report should be disclosed?
In this particular case, I didn't. Some cases...
No, I appreciate that.
Some cases...
Go on, sorry.
Some cases where they pleaded guilty, I mean, one was always aware that in these cases there was a certain amount of coercion on a defendant when they entered their guilty pleas. And so some of these cases where they raised Horizon as an issue in their interviews, we did disclose the second side and the Helen Rose report. So it wasn't... I think in some of my cases I was too quick to actually not disclose when there were guilty pleas and full admissions in interview. But
right.
Yeah, in the main, as I said, we thought we were doing right at the time, and when our cases were reviewed, they were found to be sound.
All right, fine, thank you. Miss Oliver, can you give me a prediction about how long you are likely to be? Because I'm conscious the transcriber has been going for about an hour and 20 minutes now.
Yes, sir. I think probably about 5 to 10 minutes.
Can I ask the transcriber whether she would prefer 5 to 10 minutes more and then a proper break, by which I mean at least 15 minutes, or whether she wants a 10-minute break now?
It's fine to finish. I understand the transcriber is content to carry on and then have that break.
Thank you. Well, you're usually very accurate with your estimates, Miss Oliver, so I'm confident that you will be on this occasion.
Thank you, sir. I'll try and stick to it. Good morning, Mr. Bowyer. I ask questions on behalf of Gareth Jenkins.
Hello.
I want to ask you a little bit about the Simon Clarke advice and the aftermath. In that advice, as I'm sure you're well aware, at paragraph 37, Mr. Clarke advised that Mr. Jenkins had not complied with his duties to the court, the prosecution or the defence. But at paragraph 38, he stated that the reasons as to why Mr. Jenkins failed to comply with this duty are beyond the scope of this review. Do you remember that?
I remember that, yes.
And at paragraph 63 of your witness statement to this inquiry, I don't think we need to go to it, you indicate that that discovery and the implications of the Simon Clarke advice were plainly enormous, is your words. Do you remember that?
I remember that.
When you considered that the potential implications were so enormous, did you and your colleagues not consider it imperative to ascertain the circumstances in which Mr. Jenkins had come to give evidence in the prosecutions in which he was involved?
Well, as you know, I wasn't taking the lead in this, but as far as the bugs were concerned, my understanding was that the bugs actually came either from Fujitsu or Mr. Jenkins himself, and they're not mentioned in any of the previous reports.
do I take it from that that inquiry as to the circumstances in which he came to give evidence was not something that was undertaken by Cartwright King, or at least not to your knowledge?
Well, as I said, I wasn't the lead on this, so not to my knowledge would be probably the best thing, but there are witnesses to come who will be able to answer that for you.
I'm going to ask you a few questions as to what you did, and if the answer is no, I didn't undertake that activity, then please do just say. Did you ask to see any of the written instructions that Poll or Cartwright King had given to Mr. Jenkins?
No, I didn't.
Did you seek to understand what Rachel Panter, who you described yesterday as a comparative baby, we've heard described as a paralegal, was doing in her conduct of these prosecutions for Cartwright King?
No, I mean, she was based in Leicester, and I assumed she was under the supervision of Andrew Bowles, who was there.
Did you ask any questions of Mr. Singh at Post Office as to whether Mr. Jenkins had ever been instructed as to the expert duties of disclosure?
I'm not sure. I think I was aware that he was in Misra around about this time.
Did you speak to him about his dealings with Mr. Jenkins?
No, I didn't.
And just on the topic of Mr. Singh, did he ever reveal to you any of the Horizon issues that he had been told about by Mr. Jenkins in the course of the Seema Misra prosecution?
No.
Did he ever mention, for example, that he had been told there was a locking issue in Horizon which caused transactions to be lost?
No.
That there were some 200,000 system faults recorded in the Horizon system? That Fujitsu maintained a known error log?
No.
Thank you. And a similar question, did you ever ask the question of any of the Cartwright King lawyers who dealt with Mr. Jenkins whether he had been instructed in respect of his expert duties of disclosure?
No.
Thank you. Did you ever become aware that in many of the cases that were prosecuted by Cartwright King, for example, the case of Grant Allen, Mr. Jenkins had not been provided with the audit data in order to examine what might have happened at the relevant branch?
No, I wasn't aware.
Were you ever aware of indications that Mr. Jenkins gave to Cartwright King that the analysis of that audit data would have allowed him to ascertain what the issue might have been in a given case?
I wasn't involved in the prosecution of any substantial case. I tended to come in when people asked me for a bit of advice generically.
And no subsequent investigation revealed those matters to you?
And I wasn't made aware by subsequent investigations.
Thank you. And finally, did you ever speak to Mr. Jenkins about the state of his knowledge and understanding of his role?
I never spoke to Mr. Jenkins at all.
All right. Thank you. Can we just look at one document, please? It's Poll 001 55555. Have you seen this document before?
I don't know.
All right. It's dated the 2nd of September 2013. We've heard evidence that it was authored by a lawyer at Post Office called Roderick Williams.
Yeah.
But it appears to record conversations with your colleague Martin Smith of Cartwright King.
Yes.
If we can scroll down to the bottom, please. Thank you. On the right-hand side, in the box, the handwritten box, we see the second point down, the question, what were we doing to instruct GJ, which we take to be a reference to Gareth Jenkins. And in the left-hand corner, we see M. Smith and then a series of arrows. And the first one is, don't think he's ever been advised of his duties. Do you see that?
Yes.
Were those matters that Martin Smith ever discussed with you?
I don't think so, no.
Was there any recognition, to your knowledge, within Cartwright King at the time of September 2013, when this note was authored, that there had been a failure to instruct Mr. Jenkins as an expert witness, or at the very least that there was a serious question as to whether he had been instructed as to his expert duties?
Again, not to my knowledge.
Thank you. And it may follow that you were not party to any discussions of those issues within POL either?
I don't think so, no.
All right. Thank you, Mr. Bowyer.
Obliged.
So I think those are all the call participant questions, and now would be the time for the morning break, sir. Thank
you. Well, thank you, Mr. Bowyer, for your witness statement, for coming on 2 consecutive days to the inquiry. I'm grateful for your participation.
Obliged.
So we'll now break off until 11:30, is that?
Yes, sir.
A generous 15 minutes, yeah?
Thank you.
Fine.
Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Thank you very much. We're now going to hear from Mr. Smith.
Yeah, can I suggest, Mr. Blake, in terms of breaks, that we don't try and fit in a sort of short break between now and 1 o'clock, but rather we finish for lunch a little bit earlier and time the day thereafter, so to speak.
Absolutely. In fact, we've been speaking to the stenographer, and she has confirmed that she'll make a signal if we are going on for too long. But otherwise, right, we propose to carry on until lunchtime.
Yeah, okay.
I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Can you give your full name, please?
Yes, I'm Martin John Smith.
Mr. Smith, you should have in a bundle in front of you 2 witness statements.
Yes.
The first witness statement was taken in advance of phase 4 of this inquiry. It should be dated the 21st of November 2023. Is that correct?
Yes.
And if I could ask you to turn to page 34, the final substantive page.
Yes.
Can you confirm that that is your signature?
I can.
Thank you very much. In respect of this witness statement, can you confirm that it is true to the best of your knowledge and belief?
It is true to the best of my knowledge and belief, but there is a slight amendment I do need to make to this witness statement.
And can you assist us with what that is, please?
In paragraph 104 on page 27, I refer to an email which I've sent to Stephen Bradshaw and Mark Ford. The second sentence in that paragraph, could we change Mr. Ford had confirmed to counsel had confirmed. It was Mr. Ford I was writing to, and I think it was a different counsel who had been in court, not Mr. Ford.
Thank you very much. That witness statement has the URN WITN 096801000. The second witness statement is dated the 19th of March of this year. Do you have that in front of you?
I do, yes.
Could I ask you to turn to the final substantive page? That's page 47.
Yes.
Can you confirm that that is your signature?
It is, yes.
And can you confirm that that statement is true to the best of your knowledge?
It is, yes.
Thank you very much. Mr. Smith, both of those witness statements will be published on the inquiry's website shortly. Thank you. You are a solicitor and have been since 1996, is that correct?
That's correct, yes.
You acted, I think, initially as a criminal defence solicitor.
Yes.
I think you were a duty solicitor, is that correct?
That's right, yes.
And before joining Cartwright King in 2006?
Yes.
And you were at Cartwright King until 2016?
Yes.
And I think we've already heard that you then subsequently founded a firm with Mr. Clark and Mr. Bowyer.
That's correct, yes.
And then you joined a new firm in 2020, is that correct?
Yes.
Whilst you were at Cartwright King, you were promoted to the role of senior associate, is that
That's
right?
correct.
Did you start as a junior associate or an associate or something else?
I think I was just a solicitor. I don't think there was a label attached.
Cartwright King acted in cases relating to the post office prior to its separation from the Royal Mail in April 2012. Do you recall how much earlier? We've seen, for example, documents from January 2012. Was it around then or before then?
I'm afraid I really can't recall. I think the partner in charge of the Derby office would attend court generally on an agency basis for the Royal Mail Group stroke Post Office Limited. Much of the work was carried out, I believe, along those lines, just attending court to present cases. But there became a point when case files started to be sent into Cartwright King for advice, and I really cannot recall, I'm afraid, how much earlier than April 2012 that happened.
And does that go for your own involvement as well, that you can't be sure how much earlier than April you were personally involved?
I would certainly have appeared on occasions in court on an agency basis to present a case, but I don't recall when I first started preparing advices and doing something more than appearing on an agent. I know the two case studies that I was involved in, the advices were prepared prior to the split.
So you separate being acting as an agent and having full conduct of a case?
Yes, there's a difference between the two, in my view, yes.
And what is the difference between the two?
Well, acting as an agent, you attend court, you present the case in accordance with your instructions and you report back. Once we were asked to advise on cases, that's an entirely different situation. That is requiring a lot more knowledge in terms of the role of a prosecutor than just simply attending court to present a case at a hearing.
To what extent do you consider that you had authority to make decisions in a case once you had taken on that new role?
I think the situation was very nebulous to start with, in that certainly the two advices that I've seen recently, I wasn't clear who was ultimately making decisions, and I assumed that it would be going back to the head of the legal department to make decisions. We didn't, for example, know what post office prosecution policy was at that point. There were things that we didn't know. What yardsticks were we to apply in making the decisions? Yes, we could advise in the general, but ultimately those decisions needed to be made by someone within the organisation.
When you first took over, I think you've said in your statement that the old Royal Mail cases were just provided to you without any handover or explanation.
Yes. I don't recall any handovers. I think they just arrived. And Mr. Cash, who was the partner in charge of the Derby office, would simply allocate them accordingly, distribute them to whoever he wanted to deal with the case.
And you've said you didn't see the various policies in place. Did that position change over time?
Ultimately, Cartwright King was asked to advise with regard to amendments to a draft prosecution policy. So yes, we ultimately did see a policy, and I think Simon Clark, one of my colleagues, made suggestions with regards to the proposed amendment of that policy, and I think that was at the request of Susan Crichton, who was the then General Counsel.
And is that later in, say, 2013 onwards, or would that have been in 2012?
I believe that would have been after the publication of the interim second sight report, so in 2013, I believe.
And up until that point, you were working without any policies?
Yes. I think there became a point when Mr. Singh decided how he would like the advices set out, and we followed the instructions that he provided in relation to that.
We've seen your name in quite a lot of the documents, and the same names crop up again and again. Were you one of the main solicitors in the firm dealing with post office cases?
There were very few solicitors in the firm dealing with post office cases. There was myself based in Derby, Andrew Bolts, a solicitor based in Leicester. There may have been others from time to time involved. And in terms of counsel, it was Simon Clark, Harry Bowyer. There may have been a couple of others from time to time.
If we take the 2012-2013 period together, Is it likely that you were the solicitor who had the greatest conduct of individual cases?
I don't know, I'm afraid. I think the cases were generally apportioned between myself and Andrew Bolts in Leicester.
Thank you. We're going to come and see issues relating to decisions to prosecute, basis of pleas, etc. Were you able to make those decisions autonomously without reverting to the Post Office?
In terms of decisions to charge, the advice would be given to Post Office and Post Office would make the decision. In terms of bases of plea, I believe that it would have been the common practice to revert to the investigating officer to run it past the investigating officer if possible.
Who do you understand from the Post Office to have been providing instructions in the cases that you were acting in?
Prior to the separation, it would have been the Post Office legal department, and I suppose post-separation it would have been the Post Office legal department, but the case file may possibly have come from an investigating officer directly, or it may have been that information was provided by an investigating officer.
And if you needed to consider whether to, for example, accept a plea or to make a charging decision, who do you consider would have been the relevant person to approach in that respect?
Well, a charging decision would have been put in writing and the file would have been returned back to Post Office in accordance with the instructions at the time. I can't remember the precise mechanism for the return of the file. I don't know who it went to, I'm afraid.
When you say the charging decision would have been made, though, who would it have been made by?
Within the Post Office? I'm not sure. I can't remember.
Is it that you can't remember or you weren't certain at the time?
I'm afraid I just, there could have been changes during this period of time because we've gone from having the Post Office as part of the Royal Mail Group and I believe files coming from Mr. Wilson to the Post Office splitting off from the Royal Mail Group and files being returned. They would have had formal advisors on them and I cannot recall the changes to the processes and the personnel in terms of who would have been looking at those documents.
But if we're going to today look at 2012, 2013
Yes.
period, who would you have considered responsible for making the ultimate decision as to whether to charge somebody?
Well, prior to the split, Mr. Wilson at the Royal Mail Group and post the split, John L. Singh at the Post Office.
Thank you. I want to look at decisions relating to the public interest. Can we first please look at poll 00141478, please? This is an email of the 10th of December 2012, and it's from John L. Singh to yourself, and he says as follows: Martin, John Scott's the decision maker. I think that it's meant to read concurs with Counsel Will Martin's advice that it is not in the business or public interest to proceed with prosecution of Mr. Nimesh Patel. Marin, could you write to the defence and court of the business decision and have the case listed for a short hearing where prosecution counsel should be instructed that this agreed action must say to the defence and court is not connected with the Horizon system integrity and rather simply reflect the defendant's health and associated issues. Now, I think you've said in your witness statement that you don't recall this particular case. Is that right?
I don't recall this one, no.
But we see their reference from Mr. Singh to the business or public interest to proceed. What did you understand by the business interest?
Well, this was a private prosecution, and so a business conducting a private prosecution is always going to have an interest in whether or not the case should proceed. And certainly there's also a public interest argument in terms of whether or not the case should proceed.
And did you consider those to be separate interests or one and the same?
They can be entirely separate interests.
Can we please look at poll 00411-347? This is a much later case. The case of Zen Elvins. And this is a charging advice that is written by you. If we could scroll down, please. We can see at paragraph 6 over the page a summary of what Mr. Elvins said about his case in interview. It says, Mr. Elvins made full and frank admission, explaining that he had discovered that it was possible to sell a postal order, reverse the transaction, and cash the postal order before the cut-off point every day at around 7 p.m. So it seems as though this isn't a Horizon case. This is a case of somebody admitting a way to manipulate the Horizon system. Yes. If we could scroll down, please, there is then a section entitled Discussion. And I'm going to read to you paragraphs 8 and 9. It says as follows. Whilst this case does not appear to contain an Horizon issue, I am concerned about the possible effect of commencing proceedings against Mr. Elvins, thereby putting a case into the public domain in which a suspect said, to be honest, there's so many little loopholes in the system that you kind of just find them. Sorry, if we could scroll up slightly. Thank you. We could scroll down now. Paragraph 9 says as follows. It says, my understanding is that Mr. Elvins was able to exploit a known weakness in the Horizon system. Whilst this is not an Horizon issue, to the extent that the system permitted the sequences of transactions in accordance with its programming, it does not, of course, make the position any less embarrassing for Post Office Limited. There is, in my opinion, a substantial risk that any report generated by a prosecution in this case may be utilised by those who seek to argue that Horizon is defective or otherwise inadequate. There is, of course, also the risk that the dissemination of information concerning this particular flaw may also encourage others minded to commit acts of dishonesty against the Post Office. And can we please scroll down to paragraph 11? You say at the end there, in respect to the charging decision, whilst the public interest test in this case is clearly met, for the reasons set out above, I do not regard a prosecution as being in the public interest. Now, looking at that advice and the charging decision that's made there, do you think that throughout your time acting for the Post Office, you confused what was in the Post Office's private interests with the public interest more broadly?
I think there were times when it was apparent that those interests would be aligned, but there was also times when they were clearly different. And in this case, it would be embarrassing for the Post Office to have to make public the fact that there were not Horizon issues, if you like, but failures within the system to prevent issues such as this. And it was also a weakness which could be exploited. And so it would not be in the public interest for issues which could be exploited to be widely disseminated.
So let's leave that second consideration aside, but you've very clearly said in paragraph 9 that a consideration is essentially preventing publicity of flaws in the Horizon system, because that could be embarrassing to the business.
Yes.
Do you think that that is properly a public interest?
No, I think that's a business interest.
And therefore, we can see here that you have said the public interest test is met, but you don't regard a prosecution as being in the public interest. Might it be there that you have in fact confused both the public interest with the business interest?
looking at this now and the way that paragraph 11 is phrased, I do wonder whether I should have said whilst the evidential test is met.
And how about the second part? I don't regard...
For the reasons set out above, I do not regard a prosecution as being either in the public interest or in the interest of the business, yes.
So that was a separate consideration that was wrapped up as the public interest in this advice.
I believe I've just wrapped that up very briefly there, perhaps without going into too much detail.
And do you think that this is an isolated advice, or do you think actually, looking back, that was something that was often confused in post office prosecutions?
I'm afraid I can't remember all the advices, I'm afraid.
I'm not asking about a specific written document, but looking back at your career in prosecuting post office cases, do you think that the public interest and the private interest of the business were often confused?
It's possible that they could have been.
And you were involved in them, so do you think they were or they weren't?
I can't recall.
Is it something that you need to recall, a specific instance, or can you just reflect on your career and say whether or not it's likely that you confused the public interest with the private interest of the company?
I think it's certainly possible that the two could have been confused because at times they would have been aligned, and so there was the potential for confusion.
I want to move on to knowledge of bugs, errors and defects during the 2012 period. And the first document I'm going to look at is POL 000-57362. This is an advice that you wrote in January 2012, so this is where I dated the involvement from at least January of 2012 in advising on specific cases for the post office.
Yes.
This is a case of Hutchings. If we look at the final page, we can see your name, 4th of January. It's page 3, sorry. Thank you very much. If we could go back to page 1, please. I'm just going to read a few passages from that advice. So the prosecution case, on the 30th of March 2011, an audit was carried out at the Rowlands Castle sub-post office branch, which revealed a deficit in the accounts of £9,743.76. The audit had been arranged after the branch failed to return £30,000 as requested. The next paragraph says, there is very strong evidence to support the allegation that Mrs. Hutchings had inflated the amount of cash held within the branch, usually by inflating the figure for cash held in £50 notes on the days upon which branch trading statements were completed. So there's an inflation of the amount on the day that the accounts were due to be balanced.
Yes.
If we scroll down, thank you very much, the bottom paragraph there, it says, in her prepared statement, she admitted to altering the cash declarations and suggested that she had done so only since the migration to Horizon Online, which she thought was around the months of May or June 2010. The migration date was in fact the 5th of July 2010. Furthermore, she stated that at the time of the migration, all accounts balanced, which was clearly untrue. She also gave examples of problems which she alleged she had experienced with the Horizon system, which do not appear to be of any relevance. Whilst Mrs. Hutchings has denied stealing any money, she has not put forward any explanation as to how the deficit has arisen. And then if we scroll down to the bottom of that page, in terms of charging, it says that Mrs. Hutchings should be charged with a single offence of fraud. This was, in January 2012, very much a case alleging problems with the Horizon system.
It was, yes.
I'm going to move to the summer of 2012 now. Can we look at POL 001410408? And this is a case of Jamie Dixon. And it's an email from you to Jarnail Singh. And it reads as follows. Please find attached a copy of the defence case statement in the case of Jamie Dixon. As you'll see, he has said that he does not have confidence in the Horizon accounting system or that transactions were accurately recorded. He puts the prosecution to prove that the money is missing. And you then continue as follows. You say, this is therefore another case in which there will be a challenge to Horizon. I propose to talk to the barrister whom we have instructed and explain that a robust stance should be taken at the plea and case management hearing on the 3rd of August 2012, i.e. the Horizon system works perfectly and that if the defence wish to challenge the integrity of it, their specific allegations should be particularised so that those particular issues may be further considered. And we can actually look at the defence statement in that case. That's at FUJ 00153-918. This is the defence statement. And if we turn over the page, please, to page 2. It says as follows. It says, the defendant was disorganised but not dishonest. Although he thought he knew how to operate the computer accounting system, he now realises he did not understand it fully and puts this down to a lack of training and lack of experience in serving customers. Paragraph 4 says, the defendant understands that in addition, cash in excess of £5,000 is also said to be missing. He does not have confidence in the Horizon accounting system or that transactions were accurately recorded. He puts the prosecution to prove that the money is missing. The defendant denies that he has taken the money. I'm going to move on. I'm going to show you a few documents before asking you about the position in 2012. Can we please look at poll 000-46242? This is an email in the case of Ishak, which we're going to look at in a bit more depth. You're sending Sarah Porter there. Is Sarah Porter counsel in the case?
She was in-house counsel in Cartwright King, I think based at the Nottingham office.
Thank you. You're sending her the defence statement, and it says, good morning, Sarah. Please find attached copies of a letter from the defendant solicitors and the defence case statement. The defence are clearly aware of the current Horizon issues and are on a fishing expedition. This, in my view, is a red herring. The stamp sales, which have been reversed, thereby increasing the stock and lowering the amount of money needed to achieve a balance, were clearly not there at the time of the audit. One final document that I will take you to, it's FUJ 002263331. So we're now in October 2012. If we scroll down to the bottom email, please. We have there an email from Jarnell Singh to Gareth Jenkins copying you in, and it's in relation to a case, but I'll read you the second paragraph. That says, on advice, Post Office Limited have appointed one of their investigators, Helen Rose, as disclosure officer dealing with Horizon challenges. She has prepared a document/spreadsheet detailing all such cases, past and present, approximately 20 in total, although none thus far successfully argued in court. Post Office Limited have been advised to obtain an expert's report from Fujitsu UK, the Horizon system developers, confirming the system is robust. Post Office Limited maintain the system is robust, but in light of adverse publicity from legal viewpoint is that the defence should be given an opportunity to test the system should they wish to do so on consideration of our report. So taking all of those emails together, am I right to say that in the beginning of 2012 and throughout that 2012 period, there was a growing picture of challenges relating to Horizon integrity?
That's correct.
Yes. And you had conduct of ongoing cases that raised issues of Horizon integrity whilst that picture was building up.
Yes.
We've seen in those emails references to a robust stance and to a fishing expedition. is it fair to say that, irrespective of how you feel now, the picture we see is one of pushing back against disclosure requests relating to the integrity of the Horizon system?
The picture at the time was that Post Office was saying that the system was robust. They were clear that the system was robust, and in those circumstances, we took the view, or certainly I took the view, that only such information as met the test for disclosure should be disclosed to a defendant.
Who in Post Office was assuring you that it was robust?
John L. Singh, head of criminal law, was telling us the system was robust. Stephen Bradshaw, an investigator, was saying that the system was robust. The message that Cartwright King were receiving was that the system was robust. And certainly in a number of cases that I dealt with, the requests for disclosure were either not relevant in some circumstances, or too wide, or for information which generally you would not consider would be likely to meet the test for disclosure.
I'd like to test that, and we'll look at the case of Ishak, and we'll look at developments over the period of your involvement in that case, and we'll look at it broadly chronologically. We're going to start on the 29th of August 2012. Can we begin with poll 000462444, please? So we see there a letter from Mr. Ishak's solicitors, Musa Patel's solicitors. We see there under your ref, MS2, and then it has a number. Is that your personal reference, MS2?
MS2 was my fee earner reference number, and the 24676 would be the Cartwright King file number.
Thank you. So you were the solicitor with conduct of this case?
I don't know if I had conduct of it throughout. There was and I think this case was one which was transferred to Nottingham with a view to in-house counsel preparing it with Rachel Panther. But of course, Musa Patel's would not necessarily have known of any change of personnel.
So as at the 29th of August 2012, when the defence statement was received, were you the solicitor with conduct of the case?
I don't know if anyone else had been given conduct of it.
Would it be surprising that your initials are at the top with the reference?
No, because that would have probably been lifted from earlier communications. I think there was a suggestion within Cartwright King that once the case had gone to the Crown Court, the file would be transferred to the Nottingham office. It would be then allocated to Rachel Panther and in-house counsel, and they would work on it together. And I think this was one of those such cases that was being transferred to the Nottingham office, and was actually transferred to the Nottingham office.
We know that Rachel Panther was a paralegal, has been described as particularly junior.
I believe she was a junior paralegal, but her role was to work on cases under the guidance of in-house counsel, to liaise with external counsel and liaise with Mr. Jenkins. I believe that this was one of the cases that she was intending to work on with in-house counsel, and I think ultimately, on reflection, this case became a bit of a mess because I don't think much happened for a while. And then it was worked on by her in Nottingham and myself in Derby.
We're going to see quite a lot of emails throughout 2012 and into 2013 with your name, you're sending them.
Yes.
If not on paper the solicitor with conduct of the case, did you consider at least that you were significantly involved in that case?
Yes.
And had a degree of responsibility in that case?
Yes.
This covering letter says, we enclose herewith defence statement prepared for our above-named client, and we'll have a look at that defence statement. It can be found at Pol 000582244. The defence statement is dated the 29th of August 2012. And I'm just going to read a few passages from it. If we could scroll down, please, over to the next page. The defendant sets out the general nature of the defence. Are you able to assist us with whose handwriting this is?
I don't know, I'm afraid.
It's not yours,
No, it's not my handwriting, no.
It says as follows in 7.1, there was no appropriation of monies. The Post Office Horizon software/hardware system had in the past on numerous occasions malfunctioned, causing difficulties in reconciling sales, receipt and stock figures. The defendant had reported the same to the Post Office helpline, seeking assistance, but little or no successful assistance was afforded to him despite the said request. And point 2, the defendant had of necessity to make certain adjustments by way of reversals on the Horizon system so as to ensure the sales, receipt and stock figures reconciled. This was done on the basis of a clear malfunctioning of the system and in accordance with the limited training given to the defendant by the Post Office in the past with very limited support thereafter, and not in order to appropriate any sums of money. So he's putting the reliability of the Horizon system front and centre of his defence.
Yes.
Yes. If we scroll over the page, please, paragraph 11, there is a request for various disclosure. By way of example, we have at 11.3 a request for the outcome of all inquiries in relation to other Post Office staff and or contractors who have been the subject of investigation by the Post Office or any other investigative body in relation to allegations of dishonesty related to the use of the Post Office Horizon hardware/software. Number 4, they're requesting the full results, whether provisional or final, of all internal and or external investigations and or inquiries and or reviews, whether instigated by the Post Office or any other body, into the correct functioning of the Post Office Horizon hardware/software system. And number 5 says that they are requesting any internal memoranda and or guidance notes and or other material dealing with the correct or incorrect functioning of the Post Office Horizon hardware/software system. Now I'm going to take you back to an email that we looked at very early on in your evidence. It's Pol 000-46242, and that's your email to Sarah Porter of the 3rd of September, where you say the defence are clearly aware of the current Horizon issues and are on a fishing expedition. Can we now please turn to Pol 000-46243? Do you recall sending that email about the fishing expedition?
I don't recall sending it.
You don't recall sending it?
No. I do accept that I sent it, but I don't recall it.
Thank you very much. We're now turning to an email. If we could look at the bottom of the page. On the 4th of September 2012, there is a plea and case management hearing. And we have here a attendance note of Sarah Porter. Can we scroll down the page, please? She notes there that Mr. Ishak has entered a not guilty plea. If we scroll down, please. The defence are instructing a forensic accountant. The trial has been fixed. And she says as follows: I have made it clear that our stance is that Horizon works and is irrelevant in this case because he now accepts making the reversals. And we say in doing this he was acting dishonestly to cover his tracks. Any particular problems with the system must be fully particularised before any further disclosure made. Judge has indicated the ball is in the defendant's court. Now, where she says, I've made it clear that our stance is that Horizon works, who would have been providing that instruction?
That would undoubtedly have been following a conversation with myself.
She then details, she says, specific requests. One, only such material as undermines our case or assists the defendant in light of the defence statement should be served. And then she refers to 2, 3, 4 and 5. Are these paragraphs referring back to paragraph 11 in the defence statement that we just saw? You'll recall I took you to some of those paragraphs. And she says, I understand that the Post Office are compiling some sort of database in relation to this. Can the progress of this be checked? But until the defence statement further particularised does not require disclosure. It says C, HB, is that Harry Bowyer's advice in the Wiley case?
It would be, yes.
Yes. What did you understand by the database that was being compiled?
I'm sorry, I missed that question.
What did you understand by the reference there to a database? Is that a reference to Mr. Bowyer's advice to keep a central list?
Yes. I think Mr. Bowyer had advised that a database be set up of the unsuccessful challenges to the Horizon system. I think that was following a consultation which he'd had with Jarnell Singh.
So Mr. Bowyer's advice was the 11th of July 2012. Had you, by the stage of this hearing, had you read that advice?
I have read it, but I don't know when I read it.
If we scroll up, please. I mean, her reference to a database, for example, would that have taken you by surprise, or was that something that you...
No, I knew a database was being compiled because the instructions which Cartwright King had received was that the system was robust, and Mr. Bowyer, I understood, had advised that a database should be put together of the challenges, and I know at some point I was copied into an email that Jarnell Singh sent to Gareth Jenkins. I can't just remember the chronology of it, whether that's before or after that, or after this.
I'll take you to that document. But first, can we please look at the top email, page 1 of this. You are emailing Steve Bradshaw, the investigator, copied into Jarnell Singh, and you inform them of the results of the plea and case management hearing, and you say as follows: Sarah took a robust stance in relation to Horizon. It will remain to be seen whether allegations of malfunction are particularised. However, she has asked that progress be checked in relation to the compilation of the database. So, am I right to understand that the response to Mr. Ishak's request was to try and get him to further particularise his complaint?
I thought that was sensible, because if someone could give an example of the sort of issues that they'd encountered, that would enable an expert to look into that.
Was it sensible, or was it a tactic?
No, I thought it was sensible, just in the same way that if you were staying in a hotel and you think you left your car keys somewhere in the hotel might say, well, which room were you staying in, where were you? I thought it would be quite useful to have that information so that we could properly investigate, so we could look into particular allegations that were being made.
Did the defence statement not make those allegations? I mean, we looked at some paragraphs in the defence statement where he says, in the past, on numerous occasions, had caused malfunctions, causing difficulties in recording sales, receipt and stock figures. He also referred to having reported the same to the post office. Do you not think that the post office was quite well placed to make those kinds of inquiries?
Well, certainly Mr. Bradshaw was able to make inquiries internally within the post office, but certainly I was of the view that if you could ask someone, what are you saying, as has happened specifically, that would assist.
And is it your evidence that that was not a specific tactic that was adopted in this litigation?
It wasn't a specific tactic, no.
At no point throughout the Ishak case was that a tactic?
No, I don't believe so, no. I think I wrote at a much later stage, I believe, to Mr. Ishak's solicitors, asking them whether they were going to particularise or asking them for particulars, because I didn't want to get almost to the point of trial and then find that we had then particulars which it would then be difficult to investigate at the 11th hour.
Well, we'll get to that shortly.
Informed that the post office were instructing Second Sight to carry out a review.
If we scroll down, please, over the page.
Sorry, may I just add to that?
Yes.
I'm not sure whether at that stage we necessarily appreciated that it was post office that had instructed Second Sight. I think there was a suggestion at some point that it might have been some sort of parliamentary function that had instructed Second Sight. But in any event, we knew that Second Sight had been instructed.
And that presumably the post office would have to liaise with Second Sight
Yes.
to assist them in their investigation.
Yes.
The bottom of page 2 is where we see the advice from Mr. Bowyer that we should identify the contested cases, civil and criminal, in which the Horizon system has been challenged. We should identify the areas of challenge and how we neutralise them, etc. So is this the database that is referred to?
Yes, yes, it will be.
Thank you. Moving to September 2012, could we please look at poll 000060738, and it's page 3. This is a document we're going to come to a few times. It seems to be minuting of work that is being done. Is this a document you recognise?
It is. I believe it's what we called within Cartwright King as a billing guide. It would generally list the chargeable work and some of the narrative attached to a time entry, but not all of the narrative attached to a time entry.
If we look at page 3, we're returning to the 4th of September, which was the date of the plea and case management hearing in Mr. Ishak's case. And can you see there about halfway down, just over halfway down this page, it says, discussing with SP by phone and stance to be taken re-Horizon, etc. And it has your name there.
Yes.
Are we to understand that you spoke to counsel on the day of the plea and case management hearing regarding the stance to be taken in relation to Horizon?
Yes.
And do you recall if that was while she was at court, whether it was before, whether you were providing specific instructions?
I'm afraid I can't recall that. I can see that I was engaged on that call for 12 minutes because of the point 2 that's in the right-hand column, point 2 of an hour. I don't know whether she telephoned me from court with a view to clarifying her instructions or whether I spoke to her by calling her. I don't recall. But she would no doubt have been given the brief by the Nottingham team because it was going to be dealt with in-house by the Nottingham team, and she may very well have phoned me to discuss it.
And I think you've already said that looking at the attendance note and the information, the position that she took in relation to Horizon followed a conversation with yourself.
Yes.
The email that I think you were talking about that attached various things is at FUJ 002263331. And it's the bottom email there. I think that's an email that I took you to earlier from Mr. Singh referring to the Helen Rose acting as a disclosure officer and preparing a document. and she attached there the spreadsheet of 20 cases. Is that the email that you were referring to?
Yes, and I didn't at that time look at the spreadsheet. I don't even think I realised there was 2 documents attached.
Let's look at the 2 documents that were attached. The first one is FUJ 00156648. This is a note prepared by Helen Rose. It's not what we know as the Helen Rose report. It's a note entitled Horizon Integrity Summary Report. Do you recall receiving this document?
I didn't see that at the time. It may very well be that I received it because it would have been attached to an email, but I rather took the view at the time that the spreadsheet, and I was under the impression that the spreadsheet had been considered by a number of my colleagues, Harry Bowyer, Andy Cash and Andrew Bolts, and I didn't look at the enclosures because I simply looked at the email which said that Post Office's stance is that the system is robust.
Let's look at this report. I'll read to you a few passages. Overview says, over the years, some post offices under investigation for losses have claimed that the Horizon system is at fault. As the post office is dependent on the reliability of our system to be able to prosecute offenders, we've been able to defend our system in the courts. And then it goes on to summarise various challenges. For example, in relation to the Yetminster branch, it says, during the interview, Miss Merritt produced a large document regarding an ongoing inquiry by Shoesmith solicitors in respect of the Justice for Postmaster Alliance, stating that she believed that the Post Office Horizon equipment was the actual cause of this loss. At the start of interview, Miss Merritt blamed the Horizon system and stated she had problems with transferring cash, etc. If we scroll down, there's another branch, Barkham. It's over the page. Summary, Mike Wilcox stated, along with Graham Brander, I met Mrs. Stubbs on the 17th of January, and she was convinced that Horizon was at fault. She has retained daily transaction logs for December to January, in which time she lost £9,000 and is not prepared to release until she can compare it to Fujitsu data. If we scroll down, we go on to the Rinkfield branch. Under the summary there, it says as follows. It says, during the interview, Mrs. McHugh stated that she did not feel 100% comfortable with the Horizon system, but did not appear to directly blame the system for the losses. If we scroll down, under outcome, it says, an indication was given that a plea to count 2 fraud might be acceptable, so long as the defendant stipulated in her basis of plea that there was nothing wrong with Horizon and that she was responsible for the loss and recognised the confiscation would be sought should the loss not be repaid. So a number of different cases where Horizon has been raised not even at trial, but also even at interview.
Yes.
If we scroll down, please, there's reference to the Newsom branch. We can go over the page. The defence challenged the integrity of the Horizon system and employed a forensic accountant. We then get on to West Byfleet. If we scroll down, the end of that summary, it says, an expert witness was put forward by the defence to challenge bandwagon. And it's now it's the conclusion that I'd like to look at. It says, although there have been attempts to discredit the Horizon system via the courts, to date the Post Office have been able to defend the integrity of the Horizon system at all levels. When questioning the integrity of the Horizon system, the defence solicitors are making similar disclosure requests, indicating that disclosure requests and future challenges will be similar to those made in past Horizon integrity challenges. Depending on where the loss was identified, this can sway the disclosure request slightly into requiring further details and operating procedures around specific transactions, including background processes, i.e. the processing of checks once they have left the office and electronic funds transfer records. So just pausing there on that paragraph there, is there forming an attempt to try and put pressure on defendants to give greater specificity as to the allegations that they're making about the Horizon system?
Not that I was aware of. Like I've said, I didn't read this document at the time. I don't even think that I realised there was more than a spreadsheet attached to Helen Rose's email. I saw this document for the first time when it was disclosed to me in these proceedings.
Let's look at the second attachment then. That's FUJ 001533807. And this is the list itself, the database. We see there are a number of cases that we're well familiar with. The Hamilton case, if we look in H. If we scroll down, Seema Misra. If we keep on scrolling down towards the bottom, we see, if we go to the very bottom, we see there Sefton and Neld, for example. That was a case that is described there as ongoing. Were you aware that there were not only this list of historic cases, but also at that stage ongoing cases that related to the Horizon system?
Well, I knew that this spreadsheet was designed to be a work in progress, so looking back in time, but also then being kept up to date from that point in time. But I didn't open it at the time because I didn't see the need to. I knew that it had been sent to a number of colleagues who had seen it. No issues had been raised internally about it, and Mr. Singh's covering email to Gareth Jenkins was to the effect that it was Post Office's case that the system was robust. I was copied into that and did not think it necessary to go through all of that information, given that it had emanated from Mr. Singh, Head of Criminal Law at Post Office.
But just to recap as to where we are, within a month of the plea and case management hearing in Ishak's case, you had been told, we see there in Mr. Bowyer's advice about the second site investigation,
yeah,
about various cases. Weren't those precisely the kinds of things that Mr. Ishak's team were after?
Well, I was... The short answer is yes. When I opened the spreadsheet, when I was preparing for this public inquiry, I was actually quite horrified with what I read on it, because whereas I had understood that it was a list of unsuccessful, I was quite horrified to see, for example, on and it's not on the screen in front of me now, but on the spreadsheet, there is a case where a sub-post master or mistress was able to demonstrate losses and therefore no further action was taken. So it wasn't exactly as I had understood it to be, literally a list of unsuccessful challenges. That is what I understood was being prepared, but it actually went on to contain more than that. I didn't appreciate there was a separate document by Helen Rose, because when the Helen Rose report, which we use that phrase in a different way, which was ultimately the subject of disclosure, I certainly wasn't sat there with Brian Altman, QC at the time, KC now. I certainly wasn't sat there with Brian Altman thinking, oh yes, well there's another document by Helen Rose. I simply did not realise that that existed.
If we look back at the defence statement in Mr. Ishak's case, can we look at poll 000582444? And it's page 3. list, and it refers there at 11.3, the outcome of all inquiries in relation to other post office staff and or contractors. I mean, that's precisely that list, isn't it?
Well,
it's perhaps broader than that list. But
I think it's broader than that list.
But it would include that list, or the equivalent information.
It would. The request is broader than that list, but also I took the view at the time that unfounded allegations and unsubstantiated allegations were not disclosable, and I understood that list to be unsuccessful challenges on unsubstantiated allegations.
But the request there is in relation to those who have been subject to investigation by the Post Office or any other investigative body in relation to allegations of dishonesty related to the use of Post Office Horizon hardware/software. So it wasn't simply asking for that very specific matter that you're identifying. It was a request for broader information, wasn't it?
Yes, I took the view that it was a very wide request, and indeed I took the view that it was perhaps too wide in its approach.
But having received in this attachment, because it contains a list, and that's the kind of thing that Mr. Ishak's been after.
No, I didn't, because I thought they were unfounded allegations.
So you didn't look at them because you thought they were unfounded?
Well, I was under the impression that these were unsubstantiated challenges, and I did not regard unsubstantiated challenges, unsuccessful challenges, as being disclosable. A bit like, I think that my thought process was this. If you were to ask the Crown Prosecution Service for information about the disciplinary record of a police officer, you don't, in my experience, get to know of all and every single allegation made against that police officer. You'd only get to know of any findings of misconduct.
You would, however, expect the solicitor with conduct of the case to actually look at the underlying material to determine for themselves whether they met that test, wouldn't you?
Well, I'm afraid I didn't open those documents.
Yes, and is that a failing on your part?
With hindsight, I wished I had.
Do you think that it would have been reasonable at the time, having received a list, irrespective of how detailed the list is, irrespective of whether they were successful or unsuccessful, to at least to have opened them to see whether they fit within 11.3?
Well, I didn't think to do that at the time because, as I've already said, a number of my colleagues had already seen those documents to my knowledge. Nothing had been flagged up, and we were awaiting an expert report, and so I did not think it necessary to actually look at those documents.
So your colleagues from other cases who weren't charged with Mr. Ishak's case hadn't flagged something that might relate to Mr. Ishak's case?
Well, no one had said, oh my goodness, look at this spreadsheet, look at what it contains.
Is, oh my goodness, the test for disclosure?
No, it's not. But it would be it was the view I took when I opened them when I was preparing for this.
Number 4, the full results, whether provisional or final, of all internal and or external investigations and or inquiries and or reviews. We've seen in Mr. Bowyer's advice reference to the second site investigation. Do you think that that might have fallen within 11.4?
Well, there were not. I don't believe there were full results at that point.
Whether provisional or final?
I don't know if there were provisional or final. Well,
you make inquiries about that?
Well, there weren't because Second Sight didn't report until, I believe, July 2013, and this was way before then. So I think it says See Insight 2 in someone's handwriting on that. I think that's probably a reference to Second Sight, I don't know. But certainly Second Sight had been instructed at that point but I don't believe there were any results from that. And I did go through this list with Steve Bradshaw.
If we scroll down, please, any internal memoranda and or guidance notes and or other material dealing with the correct or incorrect functioning of the Post Office Horizon hardware/software system. I mean, might, in respect of these requests, confirmation that there was this independent firm looking into Horizon have been something that's worth disclosing?
I believe that was disclosed in a witness statement by Stephen Bradshaw.
And at what point was that?
That was, I believe, the following year in 2013.
Yes. And we're here in 2012 dealing with disclosure requests. Can we please look at poll 000583777, the 8th of October 2012. It's a chaser from Musa Patel's solicitors. It's addressed to you. Do you think that might be an indication that you were solicitor with conduct of that case?
Well, they would believe that I was still dealing with it, whether it was in Derby or whether the file at that point had been transferred to Nottingham.
If we scroll down, please. It says, I was expecting the information requested at paragraph 11, subparagraph 6 of our defence statement. I think that's the Horizon data, to have been served by the 5th of October, as per the judge's order at the plea and case management hearing. Then says, I would be most obliged if you could revert back to us to advise not only on the progress of the aforementioned matter, but also other matters referred to at paragraph 11, subparagraphs 1 to 8 of our defence case statement, and of course all relevant material under paragraph 10. So there is a chaser there in relation to those paragraphs that we've just been looking at, and we're in October 2012. I'm going to take you back to your billing notes, and that's poll 000060738, please. Poll 00, thank you very much. It's page 4 now. We're in October. We're going to look at between the 9th and the 11th of October. We may need your assistance in deciphering whose name comes alongside what. It may be difficult to tell because of the way that this is presented, but let's try. If we look at the entry that says the 9th of October 2012, email for case 24676, review of file upon receipt of Musa Patel's letter. We still await the Horizon data disk from Steve Bradshaw. And then it says, although SP had taken a robust view of the defence case statement, disclosure is an ongoing process, and the developments in the Patel case may well have a bearing on D. That may well have a bearing on the defendant. Do you remember the Patel case? That may be a case called Nimesh Patel that was occurring at the same time.
Well, can I just first of all say that I believe the way that billing system works here is that it will take part of the attendance note, but not the entirety of the attendance note. So it gives a flavour of the narrative in that second column, but then it will then pick up the same for Rachel Panther, for example, below. So bearing on D, I would then regard the discussing progress of case with MGS as the start of Rachel Panther's attendance. And I'm afraid it's just how it would space it out in different columns.
Absolutely. So we see the first entry is your entry,
yeah,
which
and I
refers to a case of Patel.
Yes. And I think that it will simply just cut off the number of available characters when it says case may have a bearing on D. The rest of the attendance note will not have, if there was any, would not have been reproduced into the billing guide here. Review of the file, I'm afraid that doesn't tell me whether the file was in Derby or Nottingham, because we had electronic files as well as paper files, and that became more of an issue when files were in different locations because one wouldn't necessarily match the other.
Do you recall the case of Nimesh Patel?
I don't know whether it could be Jishan Patel.
Was there another case with the surname Patel that related to challenge to the horizon integrity in that period?
I believe there was a case of Jishan Patel, and I believe that I sought a report from Gareth Jenkins in relation to that, and he mentioned a single previous bug in that report with an earlier edition of the Horizon system, and so I don't know where I don't know, I'm afraid, with regard to the timeline, whether I had made that request at that point. I know I did make a request in the case of Jishan Patel for a report.
I'm not sure that was actually the question that I was asking. But the question I was asking is about the Patel case.
Yeah.
Were you aware of a case with the surname Patel challenging the integrity of Horizon in October 2012?
Then yes, I was. But the one I'm thinking of is Jishan Patel.
Thank you. And then we get to Rachel Panter's entry, which says as follows: discussing progress of case with MJS. Is that yourself?
That's me.
Deciding whether I should pick the case up from him, as it is very similar to Patel's case. And then she refers to the disc. She says, in terms of disc, then we concluded that I should pick it up. Review of file upon receipt of Musa Patel's letter. We still await the Horizon data disc from Steve Bradshaw. Although SP, and then it's a repetition of, I think, the attendance note that we see above. So it is clear that in October of 2012, you were aware of another case of running alongside the Ishak case where there were very similar issues being raised.
Yes. And it's clear that what I am saying there is that we have to keep an eye on disclosure. Although Sarah Porter had taken the robust stance, it's an ongoing process. We have to be aware of things that might appear in other cases. And I was thinking that something might potentially come out of another case which we might have to disclose to Mr. Ishak.
Thank you.
That's why I think it was the Jishan Patel case, because I think I was waiting to see what Mr. Jenkins put in that report, because if he put in that report information in relation to the current edition of the Horizon system, then obviously that would have made me sit up and take notice.
So only if Gareth Jenkins was addressing Horizon Online would it have made a difference to your disclosure obligations in the Ishak case, is that?
Well, I think we're going somewhat forward in the chronology now, but I think in the Jishan Patel case, I received a report from Gareth Jenkins which made reference to a single bug in the in a former version of the Horizon system. Should we just call it Horizon rather than Horizon Online? It was the previous version.
We know it as Legacy Horizon.
Okay, we can use that phrase. So I think I was made aware of a single bug in the Legacy case. I believe that was the Falkirk Calendar Square bug, which was subsequently discussed, and I did not feel that might reasonably assist the defendant or undermine the prosecution's case on the basis that was several years previously and a different version of the system.
Did it not make you question the robust line that had been taken since you started taking on those post office cases?
No, it was a single issue affecting, I believe, one branch several years previously.
Can we please look at poll 000599296? We're now in November 2012, 1st of November. a letter from Musa Patel's solicitors. If we scroll down, please. The trial is due to take place in February. And it says as follows: I write further to the aforementioned matter and confirm that we have received a disk containing core data for the duration of the indictment period. As you are no doubt aware, this should have been served by the 5th of October, and if it is to be the subject of a forensic report, then it had to be served by the defence on the 30th of November 2012. We respectfully write to inform you that it will be impossible for the defence to comply with the judge's order, and at this present moment, consideration is being given to listing the matter for an intervention hearing. Hopefully, we'll be able to address the lack of disclosure in respect of matters contained within paragraph 11 of our defence case statement and was subject to our letter of the 8th of October 2012. So that's again a reference back to those requests that were made in October in paragraph 11 of the defence statement. Sorry, that were chased in October, that were contained within the defence statement.
Yes.
We're going to go back now to the billing record. It's poll 000060738. And can we look at page 6? Thank you. If we could scroll down, please. We have there on the 20th of November an entry that, sorry, if we could scroll up slightly. Thank you. There's an entry 20th of November, and it says as follows: consider proposed letter drafted by RP, that I think is Rachel Panther, suggest amend para 1 by deleting suggestion, maybe more evidence, and repeating fact, J, I think that means judge, said Bull firmly in their court when given opportunity to provide revised defence case statement, particularising horizon issues. Is that your note?
It would have been lifted from my attendance note.
Yes. And it appears that you are suggesting amending a letter that's been drafted by Rachel Panther. Before we break for lunch, I just want to bring onto screen her draft and your draft. If we could first look at poll 000594407. This is the covering email from Rachel Panther, and she says, please can you just look at the attached before I send it? I imagine the defence will not be too pleased, but that is our position. I had to concede that the discs were served late. They may respond to say that they are unable to particularise any issues with the system until they receive the report. They shouldn't, as that was the wish of the judge at the last hearing, but without having the expert report yet to send to them, that is the best I can do for now. And I'm going to take you now to the letters. Could we bring up onto screen poll 000594416? And if it's possible to also bring alongside it poll 000594409. Thank you. So this one currently on screen is Rachel Panther's first draft. And on the left-hand side is the version that appears that you fed back on according to that billing note.
Yes.
And we can see, if I read to you on the right-hand side, it says, thank you for your letter dated the 1st of November 2012. We have been liaising with the investigator in this case and hope to serve any further evidence within 2 weeks' time. However, we look forward to receiving a revised defence case statement which particularises the issue, if any, you may have with the Horizon system as indicated by Judge Rose at the plea and case management hearing. And then the version after receiving your feedback, If we look at that first paragraph, we look forward to receiving a revised defence case statement which particularises the issues, if any, you may have with the Horizon system. We will then gladly review our disclosure obligations accordingly. So reference to further evidence potentially coming has been deleted, and what has been added is effectively a confirmation that disclosure obligations will only be looked at again if there is a revised defence statement. Is that fair?
Well, the first point I would make here is that I would generally advise people not to set themselves self-imposed deadlines. So I would have advised her to remove the reference to hoping to serve evidence within 2 weeks' time, because there had already been delays in receiving information from Mr. Bradshaw. So that's the reason why I advised that be taken out. I was still hopeful that they would serve a revised defence statement which might particularise issues. And yes, we would then obviously review our disclosure obligations.
So is your evidence once again that this wasn't a tactic to put the onus on Mr. Ishak to specify something?
I don't believe it was a deliberate tactic. No, I can see how it looks, but I don't believe it was a deliberate tactic. We were asking Mr. Ishak's solicitors to particularise the issues, which is the approach that had been discussed in court at the PCMH hearing, the Clean Case Management hearing, and it's apparent that His Honour Judge Rose at the Clean Case Management hearing on the 4th of September had made the comment to the defence advocate that the ball is in your court. So I was encouraging them, in my mind, to provide information that could be looked into.
I mean, any reference of further evidence coming their way or further information coming their way has been removed, hasn't it?
Well, I didn't think it was sensible to say we hope to serve further evidence within 2 weeks, because if I received that letter as a defence solicitor, I'd be diarising it for 2 weeks and then jumping up and down. I was very much aware that there had already been delays in this case. I don't know why there had been delays. I can't remember why there had been delays in this case, but clearly information had not been forthcoming very quickly from Mr. Bradshaw, and I was trying to avoid any issues arising out of setting a self-imposed deadline.
That's quite a generous reading of that left-hand letter, isn't it? There's no reference whatsoever in that left-hand letter to any further evidence coming at all at any time.
Well, without knowing what information Mr. Bradshaw is going to provide, we don't know whether or not it will meet the test for disclosure. So to say we will be serving further evidence on you when we don't have it, we don't know what it is, I think would be, quite frankly, a little daft.
Sir, might that be an appropriate moment to break for lunch?
Yes, by all means.
Thank you.
So 5 to 2?
Thank you very much, sir. We ask that you review your disclosure obligations if you have not already done so and revert back to us with your final position. And if you still feel that you're not obliged or willing to provide the information, then we may give thought to a Section 8 application. So they are chasing disclosure once again in this letter, aren't they?
It would appear so, yes.
Poll 00107-855. We're now in January 2013. So another month has passed. All right, further to my letter of the 4th of December, in the absence of a response and with the trial date imminent, I think it prudent to deal with the following matters and would be obliged for a response as soon as is practically possible. And if we scroll down and over the page, please. I asked for your final position in my letter of the 4th of December 2012. I made it clear that if such material is not served, then a Section 8 application would be sought. However, perhaps before reverting back to me, it may be prudent for counsel to liaise with each other as soon as is practically possible for the sake of convenience. He gives counsel's details and then says, suffice to say, in light of our defence, the material requested at paragraph 11 is clearly disclosable under your statutory duty. If we please could turn to poll 000595557, we have an email from yourself to Rachel Panter, and it says, I've received a letter from the defendant solicitors, and it mentions Gareth Jenkins' statement, and then it says as follows. It says, there is a chance it could go off. However, as the defendant solicitors are grumbling about disclosure and the lack of information on the disc prepared for them by Stephen Bradshaw, they have asked the court to list the case for an intervention hearing, and the provisional date for that is the 5th of February. Do you think grumbling is a fair description of their repeated requests for disclosure?
No, I don't.
Because, of course, it had been the post office that was taking a decision to effectively delay disclosure until they had provided more particulars.
Yes, I can't recall precisely the sequence of events, but I am under the impression that Cartwright King, either through myself or Rachel Panter, liaised with Stephen Bradshaw on a number of occasions. I just can't remember, I'm afraid, without looking at the file, all of those occasions. But certainly, yes, they were, quite frankly, right to complain, weren't they?
Yes, and not just in respect of any delays on Mr. Bradshaw's part, but we know that by this time you had received the database, although your evidence is you didn't open it.
I hadn't looked at that, no.
You had received a note by Helen Rose. Again, your evidence is you hadn't opened it.
I hadn't looked at that, no.
You were aware of a similar case going on at the time where you say that involved information about a bug. You were also aware of Second Sight investigating at this time. Was there a lack of curiosity on your part in respect of the various requests that they had been making?
And I don't think there was a lack of curiosity. I think I took the view that the requests were for, or some of the requests were either too wide or information that wasn't relevant or not going to meet the test for disclosure.
So why are you saying that grumbling isn't a fair description of what they were saying?
Well, I think it's, looking back, I think it would have been better to have rephrased that, repeating their requests for disclosure. So I also think that as a firm we were liaising with counsel as well in relation to disclosure. And so grumbling, I think, is perhaps an inappropriate term.
Doesn't it suggest a degree of ambivalence on your part?
No, it's just an inappropriate word with hindsight.
It was a word that was used because you were ambivalent in respect of their disclosure requests.
No, I was very aware that they were making repeated requests. And yeah, they'd raised this a number of times.
Can we please look at poll 00114660? And at the bottom of the first page, we have an email chain still relating to the case of Ishak. From yourself to Mr. Bradshaw and Mark Ford, if we scroll down, it says, "Dear Steve and Mark," and then we have to go over the page. "Please find attached a letter which we've received from Messrs. Musa Patels today, enclosing an addendum defence case statement. I note that the addendum defence case statement sets out the reference numbers of numerous reports which the defendant apparently made. It is the last working day before the trial, and I am somewhat suspicious that the information was not disclosed at an earlier stage. Steve, could you please go through the addendum DCS and make such inquiries as you are able to today?" Just pausing there, do you think it was right to be suspicious, given that it had been you who had been pushing them to serve particulars?
I felt that we had been ambushed. I had certainly asked for particulars, for assistance if you like, but for particulars of what they were saying at earlier stages, and this information which could have been provided at an earlier stage was provided right at the last minute. And as you recall from my evidence this morning, I said that I had written to the defence specifically asking them if they could particularise any examples, because I did not want to be in this position where at the very last minute information was being received just shortly prior to the commencement of the trial, and obviously there was very little time then to look into it.
But couldn't you have made things quite a lot easier by disclosing concerns that had been raised with you about the Horizon system quite a long time before this email?
Well, when you say concerns, which concerns do you mean?
Well, you were prosecuting somebody for a criminal offence.
Yes.
You were aware of a number of other cases raising issues with Horizon. You were aware that an independent investigator was looking into it. You were aware of another case with very similar facts. Did you not think that maybe we should provide a little more disclosure of those kinds of issues to the defence?
So by the time of this email, I think the statement of Stephen Bradshaw, which dealt with the appointment of Second Sight by Post Office Limited, had already been served. And so far as other allegations that were being made in other cases were concerned, I did not consider that they met the test for disclosure.
And you say precisely that in the next paragraph. You say, "I have no intention of providing details of previous cases in which there has been an unsuccessful challenge to Horizon. That information does not undermine the Crown's case or assist the defence." Now, your evidence before lunch was that you didn't even look at the table relating to unsuccessful challenges to Horizon.
Well,
so
I didn't.
How could you have reached the decision that it doesn't undermine the Crown's case or assist the defence if you hadn't actually read the document that had been sent to you?
Well, by virtue of the fact that they were unsuccessful challenges, I didn't feel that they would be disclosable.
Did you not think that it was incumbent upon yourself to at least carry out a very basic level of research into those matters?
I didn't at that stage, no. I was under the impression that it was a table of unsuccessful challenges, unfounded allegations, and in those circumstances, I did not consider it further.
Now, we've seen the defence statement. I don't need to take you to the addendum. In terms of the timeline, Mr. Ishak pleaded guilty to theft on the 7th of March 2013, and on the 22nd of April 2013, he was sentenced to 54 weeks imprisonment. I would like to take you to an email from March 2013. Can we please look at poll 00105209? This is an email of 26th of March, so in between Mr. Ishak pleading guilty to theft and his sentencing hearing. And And it relates to second sight reports, or so the second sight investigation. You're advising Jarnail Singh, and it's, the subject is Horizon issues urgent. And in fact, perhaps we can look at Mr. Singh's request. That's page 2, the bottom of page 2. Mr. Singh emails Andy Cash and yourself, and he says, Andy, may I have your view on this? Why the Post Office cannot simply stay and hold fire in prosecutions where there has been an alleged Horizon issue, yes or no? Can we stay something, or is it all or nothing? So Mr. Singh seems to be asking for your expertise as to whether or not all prosecutions can at that point be stayed. Is that your understanding of that email?
Well, it's one potential reading of it. Mr. Singh wasn't always that easy to understand with the way he phrased things or discussed things, but that's certainly one way of looking at it. And
what is another way of looking at it?
Just asking for general advice. Why Pol cannot simply stay, or should Pol simply stay? Yes or no? Can we stay some, or is it all or nothing? It seems to be asking for a general advice, a general view, doesn't it?
So your interpretation is he may have been neutral on the matter and was asking for your advice?
Well, it's not straightforward, is it? Why Pol cannot simply stay, that would be suggestive of the view that that was perhaps his opinion, but then his further question is, can we stay some, or is it all or nothing? So that is perhaps more open. As I say, Mr. Singh wasn't always the easiest to decipher.
And why do you think that was?
I think some of his conversations or emails were less than clear.
And why do you think that was?
Just on looking at them. I mean, looking at these two lines here.
Is it your suggestion that he had some sort of nefarious purpose or some other reason, or is it simply the language used?
I thought at the time it was the language used, but obviously as this has rolled on, I think that he perhaps knew a lot more than he was letting on.
Let's see your response on page 1.
Because if I can just say, because up to that, if you think about his earlier communications, he has been very much arguing that the Horizon system is robust, and that's very much the phrase that I placed reliance on. Then, of course, with an email like that, it makes you wonder with hindsight exactly what was going through his mind.
And what do you think was going through his mind?
Well, I'm wondering whether he knew that there were more things that we didn't know, and obviously he hadn't imparted that to us.
Your response is as follows. If applications were made to adjourn all existing cases until after the report becomes available, this would result in a nightmare situation. The fact that application to be made would send out the wrong message, and it would be assumed by many that the Post Office had found and was trying to resolve a problem with the Horizon system. Whilst it could be made known that no problems have been found by the Post Office, it is unlikely that defendants would believe such a statement. I would expect there to be numerous applications for disclosure and extra hearings and extra costs. So you're advising against staying cases because it would lead to more applications for disclosure.
I think this was generally the view of Cartwright King. I don't think this was my specific view. I think this had been discussed internally, and this was the firm's view.
Well, we see at paragraph 3, for example, it says the best approach, in my view,
Yes.
is to treat each case individually. So were you communicating your own views there?
Well, I believe that would have been my view after I discussed it internally.
The prosecution can commence in the usual way, and upon receipt of the defence case statement, any challenge to the integrity of the Horizon system can be considered. Of course, the first time we may get to know of a challenge may be in the defence statement. If a real issue is raised, the case could be adjourned until after the report becomes available. The defence could apply for the adjournment and we would not object. If, however, the challenge raised in the defence statement is flawed, has no basis or foundation or relevance, and is clearly just an attempt to frustrate the prosecution, the case can continue in the usual way. It's the same approach, isn't it? Putting the burden on the defendants to raise the issue of Horizon, to raise a specific issue that satisfied some sort of test that would prompt action on the part of the Post Office, rather than being open and honest with defendants when they raise the Horizon system as a problem.
Well, I don't see it that way. I see this as taking a case-by-case approach. There were some defendants who had made full and frank admissions in interview, and there were other defendants who the Horizon system wasn't of relevance to their case.
How are you to know if it's a real issue that's being raised? What was the criteria that would be applied for that?
I don't think we set out any criteria.
How would you test if it was a real issue or not? What would the threshold be that somebody had to raise in order for the Post Office to agree to stay their case?
I don't think I considered that point.
I want to look at what happens after this, and I'm going to move to the 12th of June and the receipt of what is the Helen Rose report. That's FUJ 000868811. So the date there is the 12th of June 2013. Can you recall when you saw the Helen Rose report?
I don't believe it was it could have either been at the end of June or the beginning of July. I do recall that we were informed that the second site interim report was going to make reference to bugs. I don't think at that point we knew anything more than the fact that there were going to be references to bugs. And then I think that either at about the same time or very shortly after a meeting with Post Office's legal team on Old Street in London, the Helen Rose report surfaced. I don't think it was before that meeting. I think it was possibly either at that meeting or shortly afterwards.
So I think in your statement, paragraph 3 of your second statement, you say that on the 27th of June, you had discussions regarding the second site interim report.
Yes.
Is it at that point that you were told about the Horizon, the Helen Rose report, or?
No, I think the 27th of June was the date upon which I received a telephone call from someone in the Post Office legal team asking me about bugs. And it was phrased in such a way which implied that they did not know of the bugs in Horizon. And I asked him what he knew of the bugs in Horizon, and he also told me that he did not know of the bugs in the Horizon system. So that was the start, if you like, of the second site interim report chapter. But I don't know how soon after that we received a copy of the draft interim report. I know it wasn't published until possibly around the end of the first week in July. I suspect that we may have received snippets or parts of that information beforehand.
It was early July. I'll take you to the various emails. Let's stick with the Helen Rose report. You said that somebody phoned you up from the Post Office.
Yes.
Do you recall who that was?
I'm afraid I don't. I don't recall who it was. I could guess, but I don't want to guess and get it wrong.
When Mr. Singh told you that he didn't know about bugs, Did you question that?
Because it had rather taken me by surprise as well. So it was apparent to me that from the way that the question team didn't know about the bugs, I was taken by surprise by reference to the bugs, and I asked Mr. Singh, and he didn't know about them either. So I just assumed that the Post Office legal team did not know about the bugs.
I'm going to very briefly take you to a couple of parts of this report. If we look at page 3, please, we'll come to look at an advice that relates to this report, but she says, for example, in relation to correspondence with Gareth Jenkins, I know you're aware of all the Horizon integrity issues, and I want to ensure that the ARQ logs are used and understood fully by our operational team. Recommendations, if we scroll down, she says, for example, however, my concerns are that we cannot clearly see what has happened on the data available to us, and this in itself may be misinterpreted when giving evidence and using the same data for prosecution. So we'll come to look at the analysis of the Helen Rose report. Before we do that, can we please look at poll 00142322? Now, this is a transcript of a conversation with Gareth Jenkins, and it's Simon Clark and also yourself are on this call. Are you aware of how this came into being?
Yes. Mr. Clark had a case called Samra that was about to start, I think, before the Crown Court at Birmingham. And he was concerned that, as a firm, we now knew of the existence of a report which we perhaps didn't have at that point, but we knew some of the content of, in that it was going to refer to bugs. And Mr. Clark was clearly concerned about whether or not that would be disclosable in the proceedings in Birmingham. And it was in those circumstances we telephoned Mr. Jenkins to try and find out some more information.
I think this is the 28th of June.
So that was probably the day after we'd been informed of the bugs.
So is that the day after the telephone call from somebody in the post office and your discussion with Jarnell Singh?
Yes.
And were you aware that the conversation was being recorded? Or was it typed at the same time, or how did this come about?
I'm not sure whether I recorded it or whether I typed it.
Did you have a conversation with Simon Clark before about the kinds of questions that you were going to be asking? We'll see that there are some very specific questions with A and B, for example. Was it something that was planned?
I don't recall discussing it with him. I'm sure he had something set out in his own mind as to what he wanted to ask.
Presumably Gareth Jenkins wasn't told that it would be recorded or noted.
No, he wasn't. He wasn't.
And it begins, hi, is that Gareth Jenkins? It is indeed. And we go on, there's an introduction from Simon Clark. If we could go over the page, please. I'll just read to you a few sections. So Simon says, the problem I've got is that we're not allowed to see the report, but we are told that there are up to 30 offices where bugs have been identified, yeah? And we know that Hurst Lane is not one of the branches where there's been an identified bug. Still with us. And Gareth says, right. As I say, certainly I'm aware of 2 bugs. Is it, firstly, is this something that has been done on Horizon, on the new Horizon system or the old system? And Simon says it's Horizon Online. And Mr. Jenkins says, okay, right. So there is 2 bugs that we have declared to Second Sight in that sort of area. We know exactly which branches are affected, and they wouldn't have any impact whatsoever on that part of what's going on. And I think we're confident that the audit trail that you are using for prosecution has not been compromised by those bugs. And then if we go over the page, please, halfway down, you're introduced. So Simon says, where are we going from here? What's the questions I posed earlier? Sorry, I've got Martin Smith here with me as well. He's the solicitor in the case. So were you the solicitor in the Samra case, or was that a different case?
I don't recall, I'm afraid. I remember what the Samra case was about, but I don't know whether I was a solicitor in it or not. It was a lady who was alleged to have been making multiple transactions using the debit cards of pensioners, suggesting the first transaction hadn't gone through and asking the pensioner to re-input their PIN number. So I do remember that, but I don't know.
Okay. And then he says, I know Martin. Hi, Gareth. Hi. It's the Horizon system is functioning perfectly. Can you assist us with what you mean there? Is that the matter that you're questioning, whether it is functioning perfectly?
I really don't know what that is supposed to mean.
Simon then says, this is the other point. Bugs have been identified in Horizon which call into question some of the aspects of the way in which it operates. That's a fair assessment, isn't it? And Gareth says, yes. And then Simon says, yep, okay, how can we be sure that A, we have identified all of the bugs that there are, and B, that although Horizon has been demonstrated that to be fallible, that insofar as the case we are conducting is concerned, we can eliminate the possibility of error. And then the response from Gareth is, right, I mean, clearly you can never say there are no more bugs in the system, but we've got to be careful about trying to say anything like that. But what we can show is that nothing has been found to show that there is a problem in the integrity of the audit trail, which is what has been used for the your evidence. And Simon says, so your view is that that if the defence were to suggest that there's a problem with Horizon, and therefore we can't rule out that there might be other problems with Horizon, what you say is, as far as you're concerned, the integrity of the system is intact. And he says, yes. Did you have concerns, real concerns, at this time, June 2013, about the reliability of the expert evidence that had been provided in court?
Mr. Clark certainly had some concerns at that point, because as part of our conversations within Cartwright King, I provided him with a number of reports that Mr. Jenkins had prepared at Cartwright King's request. And obviously there had been a discussion about that. So yes, there was a concern at that point within Cartwright King about the evidence given by Mr. Jenkins.
You've seen there, I mean, you're having a conversation with the man who's given evidence in some of your cases. I mean, Ishak case, Mr. Jenkins gave 2 statements.
Yes.
There's reference there to 2 particular bugs. There's reference there to you can never say that there are no more bugs. Did you personally not have a real concern about those cases that you were involved in?
I expressed concern to Mr. Clark that Mr. Jenkins had not raised those bugs during the currency of the case against Mr. Ishak. In fact, I do recall that when Mr. Ishak had suggested in his one of his defence statements that the losses were attributable to a freezing screen. I thought, my personal view was that he was suffering rather large losses attributable to a freezing screen. I thought, if anything, there was more to that. And I specifically asked Mr. Jenkins at court whether or not there had been a bug affecting Mr. Ishak's branch, and he had said not. And so by the time we get to this point, yes, you are quite correct. I was concerned about Mr. Ishak's case because Mr. Jenkins had said that there had not been a bug in his branch, and here we are now being told of 2 bugs by Mr. Jenkins. And I can recall discussing that with Mr. Clark, and I explained to him that Mr. Jenkins had said that there were no bugs operative in the branch, and that Mr. Ishak had pleaded guilty. Mr. Clark's view was, well, that wasn't really to the point. Those bugs should have been disclosed to him.
And did you, at the time of recording that conversation, had you put 2 and 2 together at that point, that it wasn't just there were these bugs, but also that we have a problem with the expert that has given evidence in our cases?
Yes, that was discussed.
Was that information disclosed in ongoing criminal cases?
So far as the ongoing criminal cases were concerned, this all happened in a very, very short window. I believe that Susan Crichton and Simon Clark discussed the position and decided that it was appropriate, clearly in the circumstances, to impose a moratorium on all new prosecutions, so that there'd be nothing new entering the prosecution pipeline, and that in existing cases they would be reviewed by Mr. Clark, and depending on the nature of the case, it may be appropriate to terminate it in the absence of a new expert.
Was there not a real sense of urgency at that point, having found out that information?
Well, I think all this happened within a couple of days.
I mean, Mr. Clark's advice was only on the 15th of July, so a couple of weeks later. And you had been involved in the Ishak case. A man had gone to prison. Did you not think then and there, I've got to do something urgent about the cases that I was personally involved in?
I do recall expressing my absolute... well, I was actually quite upset about the position that there had been bugs which hadn't been disclosed in Mr. Ishak's case. And I remember actually feeling quite angry about that, because a man had gone to prison, and quite frankly, those bugs should have been disclosed. I asked Simon to review the case as a matter of urgency, and I believe that he did within the next day or so. I certainly have it in mind that it was reviewed very quickly.
Why did you need Simon Clark to review the case? Why couldn't you, who had conduct of the case, then and there, do something about your anger?
Well, I just thought it was appropriate to have a senior barrister dealing with it.
Can we please look at poll 000060572? We're now on the 30th of June. John L. Singh is passing on information to various colleagues at the post office. And if we scroll down, he refers there to the case of Ishak at the top. He then refers to the case, the Dixon case. And he says, it follows that in some cases the integrity of the Horizon system has been challenged by the defendant. In other cases, the integrity of the Horizon system may become an issue, notwithstanding that there has been no specific challenge. And he then says, the Samra case above in Birmingham involves Horizon, so that's the case that you were talking about.
Yes.
With Gareth Jenkins. Samra is accused of performing unauthorised transactions on the post office's current account of a number of vulnerable people. She has consistently denied any wrongdoing, and the primary evidence against her is taken from the Horizon system. And it's this paragraph next that I want to ask you about. It says, Simon Clark, prosecution counsel, and Martin Smith spoke to Gareth Jenkins on Friday the 28th of June. He told them that he had only volunteered information about 2 bugs present in the system to Second Sight. He also told them that those bugs would not have affected the integrity of the data being used in the SAMRA prosecution. If I may speculate a little here, Gareth Jenkins only told Second Sight of 2 bugs. The Post Office only knew of 2 bugs. It seems, therefore, unlikely they would find other bugs without Gareth Jenkins knowing about it, due to the mechanics of the system, reporting and the checks and balances already built into the system. It looks likely that Second Sight's report will focus on these 2 bugs. Just pausing there, do you think that is a fair reflection of the conversation that you had with Gareth Jenkins on the 28th of June?
Well, no, it isn't, is it?
One thing it doesn't suggest is, for example, the unreliability of Gareth Jenkins and the evidence that he has given.
No.
It also doesn't refer to that paragraph we saw about never saying that there aren't more bugs in the system.
No, and it's also confusing in that well, I don't really think I necessarily follow this. If I may speculate a little here, Gareth Jenkins only told Second Sight of 2 bugs. The Post Office only knew of 2 bugs. That's contradictory to the information he told me. And it says it seems therefore unlikely they would find any other bugs. Well, I don't know where he's got that from, because that certainly wasn't discussed with Gareth Jenkins on the 28th of June.
So the question that arises from that is, did you provide John L. Singh with the level of detail relating to the problems that Gareth Jenkins had told you about, or not?
We would certainly have communicated with Mr. Singh and kept him informed of developments. I mean, after all, he was head of criminal law.
And your real concerns about the reliability of Gareth Jenkins, had you by then, the 30th of June, passed those on? Because there's no mention in that paragraph, summarises the conversation but doesn't mention issues about the reliability of evidence. Do you think that you did or didn't pass that on to Mr. Singh?
I cannot recall what I said to Mr. Singh.
It then continues, it's not possible to ignore the fact that Second Sight may report in the immediate future. Similarly, it's not possible to ignore the fact that there may be high-profile debates relating to the integrity of the Horizon system this coming week. Prosecution counsel proposes to mention the position in private to the judge in the SAMRA case in his chambers on Monday morning. The Post Office, as a public body, has to be open and honest for the judge to ensure fairness to elderly witnesses, prosecution and defendants whose liberty is at stake. Why mention it to the judge in private?
I was being guided entirely by Mr. Clark in relation to this. And he was prosecuting counsel in that particular case, and he advised as to the best way forwards in relation to this particular issue that had arisen. I mean,
when the expression "in private" is used, do I take it that that simply means without the public being present? It doesn't mean without the defendant's representatives being.
And Mr. Clark explained to the judge from memory that there was a report which he was not yet in.
All right, sorry, Mr. Blake, for jumping in.
Not at all. Why not mention that in open court?
spent dealing with defence work. I had then started dealing with prosecution cases on an agency basis, appearing in court for particular hearings and then reporting back. And then this was effectively a new chapter of work actually dealing with prosecution cases and advising in relation to them. And quite frankly, I was grateful for any guidance that I could get internally within Cartwright King. And this was Mr. Clark's advice, and so that's what he did, and I went with him to the hearing.
You had worked for Cartwright King for 6 years by this stage.
Yes.
Was the training so inadequate that you had to rely on Mr. Clark in this respect?
Well, I was quite well. There had been no training in terms of prosecution work at all, no training at all that for example, a CPS lawyer might get internally at the Crown Prosecution Service. We'd been on no courses. And I think also the perception of the firm was that it would be more appropriate, so far as Post Office were concerned, to see a senior, experienced barrister advising, one who had had much experience of both prosecution and defence work. So he was the one who took the lead.
A reading of this is that it would suit the Post Office because it wouldn't be publicised. Did you understand that to be the position?
Well, no, I didn't. And in fact, when we had the conference with Brian Altman, KC, he was very clear that he would not have dropped the Samra case. Was going to end up in the public domain. It was always going to be published, it was always going to be made public, and it was going to be disclosed in other cases. The fact here is not a case of trying to prevent that report from being provided. It was going to be provided through other routes. As I understood it, Mr. Clark's concern was that he could not comply with concern that it had been arranged by Parliament or organised by Parliament and parliamentary privilege attached to it. I remember a conversation along those lines, and he was quite clearly unwilling to say very much about it.
Is that a conversation with Simon Clark?
To start releasing information from it, or I don't know whether we had the report at the point of the application. Or just a part of it, or just information in which we either didn't properly have or couldn't provide when it was yet to go to MPs the day before publication.
Do you think that there was email correspondence on that issue?
Well, certainly not between myself and Mr. Clark, no. As I see it, this was a case of Mr. Clark saying we cannot comply with our disclosure obligations at the present time in relation to this imminent case. This was a case which involved, as it says here, a fraud, if you like, involving numerous elderly people who had had their cash cards used twice to their knowledge, well, without their knowledge, once with their knowledge and once without. One possibility was to seek an adjournment. That adjournment would be likely to be quite some time, and of course one would have to consider the effect of an adjournment on a decreasing number of victims because of their vulnerability and age. And so this was never a case, in my view, of not wanting to disclose the second sight interim report. As I say, that was always going to end up in the public domain via one route or another. This was a case of Mr. Clark saying, I cannot deal with my disclosure duties here and now at this particular point in time.
It's also, I can't tell anybody that it even exists.
Well, we told Mr. Clark
apart from the
explained the position in chambers to the judge, and I understand that if I remember correctly, that application was recorded.
Can we please have a look at poll 00190843? Actually, sorry, if we could start with poll 00190842. This is an email from Hugh Flemington to yourself, and he says, please find attached a first rough draft from second sight of one half of the interim report. This will be supplemented tomorrow by a section on spot reviews. Please would you let us have you material and significant concerns on this first thing tomorrow morning, please. If this timing is not possible, please shout as soon as possible. And we see there the attachment is the interim report version 18A. If we look at poll 00190843, so this is the 4th of July, and this is the version 18A that was attached to that email. If we could look, please, at page 6. Page 6, 6.4, 6.5, 6.6, these are the receipts and payments mismatch and local suspense account bugs that we'll see in the final version of the second sight interim report. And if we scroll down, we can see various other concerns that are raised relating to the Horizon system over the page, please, under thematic or systemic issues. Various issues that have been reported by sub-postmasters. That was the to be disclosed in any case. The decision would need to be taken on a case-by-case basis, raising in relation to the private hearing before the judge. That is, on your part and on Cartwright King's part, a concern about adverse publicity.
Going to end up in the public domain. That application was made because Mr. Clark was concerned that he could not properly discharge his disclosure duties. And clearly, this is an email that both myself and Mr. Clark have put together, because as you'll see next to the yellow square that's on the left-hand side, it's our advice overall. This is very much the stance of Cartwright King, myself and Simon Clark having discussed the position.
Yes. The concern that I mentioned in relation to the hearing before the judge is a concern to have it in private, not about what would be said, but the concern about adverse publicity. Did you not recognise that that might be a concern?
Not in relation to that hearing, no. I just assumed that was the correct way to go about things because that was what Mr. Clark advised.
And sticking with this email, is your advice relating to adverse publicity and speculation, is that similar to where we started today, a confusion between the post office's private interests and legal requirements?
No, I don't think it is. I think the danger with disclosing a partial report is that you're only disclosing part of the picture. Isn't it best to see the entire report and then make decisions?
But why should publicity be a concern of somebody who's advising in criminal prosecutions?
I think this... Sorry, can you just scroll up? What's the date of this email?
The 5th of July.
So this would follow a meeting which had taken place at the headquarters of Post Office Limited, which at that point were an old street in London. And I think at that point, Post Office was expressing concern that there could be adverse publicity and keen to avoid speculation.
So it was the Post Office rather than...
So I think this is going back to the concerns which would have been raised at that meeting. So I think our approach to this would have been that it would be better to await the full report and then make decisions, rather than start to disclose bits of a report and have adverse publicity and speculation in relation to the gaps.
And then, having said that, the second site report would not need to be disclosed in every case. That decision would be taken on a case-by-case basis. In many cases, it will not be disclosable. Is that right?
I think where we were at the time, that was our thinking.
I mean, you had had that conversation with Gareth Jenkins where he said there might be more bugs that caused you real concerns about the evidence that he had given in criminal prosecutions and his reliability. Do you think that such a strong line could really be taken?
Well, if you look at the file review process that was subsequently undertaken, I think out of the total number of cases which we reviewed, the second site interim report was disclosed in a proportion of them. So I think the view that we took within Cartwright King at the time is that it certainly wouldn't need to be disclosed in every case, but depending on what it contained, a decision would have to be taken on a case-by-case basis. And
that is absolutely an issue that we're going to be coming to in due course. Can we please look at poll 00297-237, please? Just to assist us with the timeline, in fact, it was the very same day, an hour later, that you received the full report, full draft report
right.
Still, so that would have been the second half relating to spot reviews. We can see there Ian Henderson at the bottom is sending the latest version, version 24 of the draft report. And if we see at the top, Roderick Williams has sent it on to you. Can we please now look at poll 00006545 and page 4. Bottom of page 3 onto page 4, please. We have an email from yourself to Hugh Flemington, and you say, "Dear Hugh, please find attached a copy of the letter which we propose, subject to your agreement, to send to Ishak Solicitors." So this is the 10th of July. I think your evidence before was that quite promptly you did write to Ishak's solicitors, and this is that correspondence.
Yes, I couldn't remember how promptly, but it certainly predated the file review process.
Yes.
I think I was so concerned about Mr. Ishak's case that I actually circumvented the sifting process. I didn't see the point in putting it through a sift. I knew it needed to be reviewed, and I brought it to Mr. Clark's attention for it to be reviewed. So this was something that was dealt with, if you like, outside of that the main file review process.
Can we please look at the draft letter? It's poll 00323836. So in April 2013, he had been sent to prison. This is a letter in July now. I'm going to read to you that letter. It says, "We write to your firm as being the solicitors on the file representing this defendant in the proceedings, which resulted in him receiving a term of 54 weeks imprisonment for an offence of theft. On the 8th of July, a report into the operations of the Horizon system was published by an independent organisation which had been commissioned by our clients, Post Office Limited. The report is known as the Second Site Interim Report. We have also received and considered a second report concerning an investigation into an incident at another post office, the Helen Rose report. We have thoroughly reviewed both the prosecution case and that of your client, and in particular his defence statement and addendum defence statement in the light of material contained within the Second Sight interim report and the Helen Rose report. We have also reconsidered our disclosure duties under the Criminal Procedure and Investigations Act 1996 and the Code of Practice enacted thereunder and the Attorney General's guidelines on disclosure. We have formed the firm view that had the prosecution been possessed of the material contained within the two reports during the currency of the prosecution of your client, we should and would have disclosed that material to you in compliance with our disclosure duties. Over the page, please. Accordingly, we now disclose those reports to you so that you are able to consider whether your client may have grounds for an appeal against his conviction. We would also remind you of your duty not to disclose this material to any third party other than your client. In particular, the Helen Rose report is not in the public domain. So the proposal is to now disclose to Mr. Ishak's solicitors the Second Sight interim report and the Helen Rose report. Is that right?
Yes.
No apology in this letter, correct?
There is no apology in that letter, no.
No reflection of any wrongdoing or concerns about material not being brought to Mr. Ishak's attention that really should have. No apology for that.
No, the letter is as you've read it.
And it ends with no sharing allowed in relation to the Helen Rose report. Is that again a concern about the publicity that might raise?
I have I didn't consider that point. This is the letter as Mr. Clark prepared it.
If we could zoom out, please, just to look at the entirety of the text. Is there any reference in that letter to concerns about the reliability of Gareth Jenkins?
No, there isn't.
Do we find also attached the list of cases relating to Horizon concerns that had been prepared by Helen Rose back in October 2012?
No.
Why were the Second Sight report and the Helen Rose report considered to be sufficient?
At this point in time, I was unaware of the content of the spreadsheet and the first Helen Rose document. And these were the documents that we had been provided with.
We are also concerned about a witness in your case who was referred to as an expert witness who we believe gave unreliable evidence. Is that set out there?
No, it isn't.
Do you know why not?
I'm sorry, I can't answer that question. I don't know.
As somebody who was involved and a firm that was involved in the original prosecution, do you think Cartwright King were the right people to determine how much additional disclosure should now be provided to Mr. Ishak?
At the time, yes, I did think it was appropriate. I remember Mr. Clark explaining around the 3rd of July meeting in London that it was not inappropriate for a prosecutor involved with a case to review the case to determine whether further disclosure ought to be made.
Can we please return to the email chain we saw just a moment ago, poll 00006545. We looked at the final entry in this chain, which was you sending this draft to the post office. Can we please start on page 3 this time? Roderick Williams sends you a response thanking you and says, first point, we presume that Helen Rose's report is being disclosed because the Post Office's evidence in the prosecution included an ARQ report. Is that right? Second point, Helen Rose's report is marked confidential and legally privileged. I understand that she did this because she prepared the report to give to Post Office Legal for legal advice on the implications of her investigation. Please therefore consider what information from the report needs to be disclosed to Ishak solicitors and in what format, i.e. whether parts of the report should be removed or redacted, or the non-privileged material repackaged for disclosure to the defence. If you advise that Helen's report does not attract any privilege, please ensure reference to privilege is removed. We'll look at the other email in the chain, but just pausing there, I mean, what was your impression of how open the Post Office were to providing disclosure to Mr. Ishak at this time?
It's difficult to recall, but my impression was that they were content to follow Mr. Clark's advice.
If we turn to page 1, it's an American format of the date. It should be the 11th of July. For those who are interested, we have another version of this. It's at poll 00323841. It doesn't need to be brought up on screen, but that shows it as 11th of July, which makes sense in terms of the sequencing.
Yes.
You're emailing Roderick Williams about privilege, and you then have a section, why Helen Rose's report is disclosable, and you highlight features such as those that rather suggest that there may be horizon issues plus training and support deficits, and you highlight the reference there to horizon integrity issues and say, this is an alarming statement, for it is suggestive of the existence of horizon issues and that they were known to Gareth Jenkins. This has obvious implications for Gareth Jenkins's court reports and appearances and his silence therein. And note that that, as I say, was not referred to in your draft, and I think you accept that. If we scroll down, we see there, paragraph 3, you refer to Helen Rose's ultimate conclusion is that this is not an issue which suggests a failing in Horizon itself, rather it's an issue of data presentation. Whilst to a degree that is correct, given what I have said in 1 and 2 above, that view may not be entirely sustainable. It may be suggested that the report is at the very least suggestive of horizon issues. And then you go on to say, the report in general terms reinforces the impression that Gareth Jenkins is not being entirely forthcoming about horizon issues. An example of this approach may be found within his response to Helen Rose's first question, where she asks, also, could you explain what happens when the system fails? Gareth Jenkins does not begin to answer this question. He simply responds, the system is behaving as it should. If the system is behaving as it should, then the answers I reproduce in my point 1 above are inexplicable. 5, some may conclude from this that Gareth Jenkins' aim is to protect Horizon from criticism rather than to provide the Post Office and the court with impartial and honest evidence. In view of these matters, I think that the information contained in the Helen Rose report meets the test for disclosure. It should not be forgotten, however, that information would only meet the test in a limited number of cases, i.e. those where the defendant had conducted reversals and was blaming Horizon. I mean, just pausing there, is that right? I mean, again, we're seeing an email from yourself that is narrowing the number of cases in which this needs to be disclosed.
Well, you say it's from myself and Simon, as you'll see how it's signed off.
Yes.
This is a joint effort, and I'm clearly taking advice from Mr. Clark.
I mean, sent by you.
It's sent by me, but if you have a look at the screen at the moment, under kind regards, it's Martin and Simon.
Yes.
So this is clearly a joint piece of work.
Does that make it any less troubling?
What it means that I am clearly taking advice from a senior in-house barrister about the position.
It then says, accordingly, you may take the view that I should attempt to, in view of the matters, I'm in no doubt, in fact it says I there rather than we, but
it does.
We can put that to one side, that this document is disclosable. On the LPP point, I rather fear that if the matter were to come before a criminal court, the judge would, without hesitation, order disclosure in the appropriate case. Accordingly, you may take the view that I should attempt to redact or summarise the report into a disclosable document and in a form which serves the dual purpose of both disclosing that which should be disclosed whilst protecting the non-disclosable sensitive material. Well, first of all, by this date, it seems as though you are getting quite concerned about how candid the post office have been. Is that a fair summary of the contents of that?
Well, this Helen Rose report has clearly now arrived, and it's in addition to the 2 bugs referred to in the second site interim report. So there is another report to deal with. I don't think I gave it much more thought. I can recall that it was Mr. Clark who then went on to redact the Helen Rose report before it was sent out, and it was Mr. Clark who then drafted the letter to be sent out to the intended recipients.
At paragraph 14 on page 5 of your second statement, you very candidly say that you are unaware of the post-conviction duty of disclosure. Is that correct?
Yes, I wasn't aware of that.
I mean, wasn't that precisely what you were being asked to do by Roderick Williams, to consider such duties?
I became aware of the post-conviction duty of disclosure upon discussing Mr. Ishak's case with Mr. Clark, because I pointed out that Mr. Jenkins had said that there had been no bugs in the branch, and Mr. Clark's view was that, well, this is still disclosable because it would give Mr. Ishak the opportunity to argue that there were perhaps bugs as yet unknown to Post Office, and therefore this should be disclosed. I had not been in this situation before, needing to consider post-conviction disclosure. I was simply unaware of that.
Is that of concern, given that you had been involved in quite a few criminal prosecutions for a number of years by that stage?
Well, everything was going to be reviewed, wasn't it? That was the point. We were then going to review things.
But was it of concern that you, a person who had conduct of cases, a solicitor who had conduct of cases, wasn't aware of the test for disclosure once people had been convicted?
I didn't see it as a concern. I regard it as professional development.
Do you see it as a concern now that you weren't aware of that test?
I do, yes.
Thank you. So that might be an appropriate moment to take our mid-afternoon break. If we could come back at 25 past, please.
Yes, certainly. Just before we go, though, and stop me, Mr. Blake, if you're going to continue to pursue this, but I'm still baffled about how it can be, Mr. Smith, that you quite rightly take the view that the Helen Rose report and the second site report should be disclosed. But there doesn't appear to be any consideration at all about the disclosure of your discoveries relating to Mr. Jenkins, if I can put it in that way. Because in particular in relation to the Helen Rose report, but really in relation to both, all of those matters are inextricably linked, are they not?
I cannot recall, sir, any discussion within the office about disclosing information with regard to the position with regard to Mr. Jenkins. I don't recall that being discussed at that point, or indeed...
But that in itself is, let's just say, surprising, is it not? Because you have your conversation with Mr. Jenkins on the 28th of June. That immediately raises alarm bells, one would imagine, and I think that's the purport of your evidence. We then get sequentially Second Sight and Helen Rose in quick succession, literally within a short number of weeks from the discussion with Mr. Jenkins. And on the 15th of July, Mr. Clark actually puts in writing, in unequivocal terms, his very many misgivings about Mr. Jenkins. So it does seem very odd that this isn't a topic of discussion, in particular in relation to what you're going to do about Mr. Ishak, who may or may not still have been in prison at that point. Anyway, there we are.
Well,
25 past 2. 3, sorry.
So I think Mr. May just answer.
So would you like me to revisit that after the break?
Yeah, by all means. Think about it.
Well, I can answer it now, but I'm aware
Right.
that
Go
we're
on,
about to have
yeah.
a break.
Yeah, go on. We'll extend the break till 3:30. You answer it.
Okay, thank you. So there was literally no discussion, as I recall, about disclosing information about Mr. Jenkins, and when we subsequently went to see Brian Altman, KC, to discuss the file review process and the letters which were being sent to others with regard to post-conviction disclosure, I don't recall it being mentioned then. I don't recall it being suggested that a paragraph should be inserted to deal with Mr. Jenkins.
Well, no doubt that is an issue that will be taken up sequentially with the lawyers who come after you, Mr. Smith. Thank you.
Thank you, sir. past. Thank you, sir. Moving on to the Criminal Cases Review Commission, can we please look at poll 00039994? They send a letter on the 12th of July 2013, so the same time period as the documents we've just been looking at, around the same time as that letter was being drafted to Mr. Ishak. If we scroll down, please, it's sent to Paula Venables. And it says, for obvious reasons, we have read the recent media coverage concerning the Post Office Horizon computer system with interest. Clearly, it would be very useful for us to have more information directly from the Post Office, especially accurate information as to the number of criminal convictions that might be impacted by the issue and what action is proposed or being taken in that respect. So this is in following the publicity relating to the Second Sight interim report.
Yes.
Could we please turn to poll 00039998? Do you recall as a firm being tasked to draft a response to the letter?
I think we were. Well, it would appear that we were, but I don't recall it.
We have here an email from yourself to
Yes.
Susan Crichton. Susan, please find attached documents prepared by Simon in response to the letter from the CCRC. And if we scroll down, we can see Simon Clark. Herewith my response to the CCRC letter. The PDF is simply a brief discussion of CCRC's criteria. The Word doc is a draft response for poll if they think it may assist. Do you recall it, if this was something simply volunteered by yourself and Mr. Clark, or whether it was something that was specifically requested by Susan Crichton, or something else?
I'm afraid I can't remember.
Could we look at the first document that was attached, and that's poll 00039998? Sorry, poll 00039993. Do you recall seeing this document? This was attached to that email that you sent to Susan Crichton.
I don't know whether I considered it in any depth.
Do you recall why this was prepared?
I would imagine that Mr. Clark was simply providing information at the request of Post Office Limited and the legal department. But I can't recall having anything really to do with this, apart from sending it on.
Can we look at the other attachment, and that's the draft response? It's poll 00039995. These are the draft paragraphs for insertion into the reply. I'll just read to you a few sections from this. The second paragraph, halfway through, it says, the detection and successful prosecution of such offences is almost always dependent upon a proper analysis and presentation of Horizon data, and accordingly it's imperative that the integrity and operation of the Horizon system is demonstrably robust. In many prosecutions, the defence will fall into one or more of the following categories, and then a number of categories are identified. And then it says as follows. It says, where a defendant asserts, rightly or wrongly, that Horizon is at fault, it is for the prosecution to demonstrate the integrity of the system and the evidential audit trail derived from Horizon. Just pausing there, is that the approach that you think the Post Office took over the years, that it's for the prosecution to demonstrate the integrity of Horizon, or do you think from what we've seen already today that there was a fair bit of a burden put on the defendants themselves to particularise their complaints?
No, as I've said in my statement, my second statement, the approach taken by Cartwright King was not to obtain a report in every case where there was a suggestion that the Horizon system might be at fault or some unexplained loss, the approach taken by the firm was a sort of wait-and-see approach, and if the defendant didn't plead guilty, then a report would then be sought, which of course is something very different.
It then says this is usually accomplished by the serving of expert evidence. For many years, both the Royal Mail Group and latterly the Post Office has relied upon a single expert witness provided by Fujitsu Services Limited, the Horizon manufacturer, maintenance and support contractor. That witness has provided expert evidence in many cases where the defendant has asserted irregularities with Horizon to be the cause of unexplained shortfalls. As to the operation and integrity of the Horizon system, he has done so both to the Post Office and in expert witness statements and oral evidence to the court. In particular, he has attested to the presence of defect detection and rectification systems, the robustness of the prosecution audit trail, and stated that, in his expert opinion, Horizon accurately records and processes all information submitted into the system. The second site interim report demonstrates that this was not the case. What isn't mentioned there is your real concerns about the reliability of Mr. Jenkins' evidence. Is that?
No, there doesn't appear to be anything there about that.
No. If we continue, I mean, Simon Clarke's advice on the reliability of Mr. Jenkins was the 15th of July, so the day before this draft was produced. Do you think it is surprising that this letter to the Criminal Cases Review Commission...
At the time, I don't think I gave it any thought, but looking back, I take the view it should have contained information relating to Mr. Jenkins.
Actions taken by the Post Office. The Post Office accepts that a number of criminal convictions may be impacted by the matters highlighted in the second site interim report and has taken early and determined steps to identify those cases where such an impact may fall. So there's mention of second site here, but there isn't mention of the Helen Rose report either, is there?
No, there doesn't appear to be.
And then the next paragraph, to that end, the Post Office has instructed an independent firm of criminal specialist solicitors to identify every criminal case prosecuted by the Post Office and Royal Mail Group prior to their separation, and in any event in the last 3 years, so as to determine in each case the answer to that question. Instructed an independent firm of criminal specialists, is that correct?
That would be Cartwright King.
And having prosecuted a number of those cases, do you think it's fair to describe Cartwright King to the CCRC as an independent firm of criminal specialist solicitors?
Well, I guess the answer to that is we were independent of Post Office, so we weren't within Post Office's legal team, and we were external to Post Office, but of course we weren't independent of the actual prosecutions because we had conducted a number of them.
If we could go over the page to page 3, please. If we scroll down, number of impacted cases, it says, where counsel has advised the possibility of grounds to appeal, letters have been written to solicitors who defended, informing them of the issues and providing copies of the second site interim report and such other material as they ought to have received during the currency of the prosecution, had we then been possessed of that material. It would then be for the defendant and his lawyers to determine whether or not they wish to launch an application for leave to appeal out of time. We would certainly support grounds to allow the application out of time. Again, reference there to the second site interim report, but no mention of Helen Rose report or any other specific information set out there in that draft letter. Is that correct?
Yes, I also think, looking at that paragraph, it's saying letters have been written to solicitors who defended. I'm not sure the letters went out that promptly.
And it concludes, thus far, the review has identified no cases where the defendant has sought the leave of the Court of Appeal to appeal against his conviction. One case has been identified where the defendant sought and was refused leave to appeal against his sentence. Sorry, if we go over the page, please. We then have Magistrates' Courts convictions, a section on that, and it's the final passages of this draft that I want to now ask you about. It says, we take the view that it is incumbent upon the Post Office as a major public institution to take every reasonable step to ensure that only the genuinely guilty are convicted, and that those who are or may have been convicted without good reason have every opportunity of correcting such a miscarriage of justice. Do you think that that fairly reflects the very narrow approach that seems to be taken to disclosure of matters that are well known by this stage to the Post Office?
Well, at this point in time, there were very few matters known. There was simply the 2 bugs and the Helen Rose issue. The Helen Rose report, in my mind. So
you had sent this draft, it seems to be authored by Mr. Clark, but you had sent it to the Post Office.
Yes.
Presumably you read it before you sent it.
I don't know whether I did or not.
Would it be typical of you just to forward things to the Post Office, or would you consider matters such as a response to the Criminal Cases Review Commission relating to cases that you have prosecuted?
No, if Mr. Clark had drafted something, I would have trusted him and forwarded it.
You are sending a letter to the Post Office which makes absolutely no mention of the kinds of concerns that the Post Office had at that stage about Mr. Jenkins, within days of Mr. Clark's actual advice on the impact of Gareth Jenkins' evidence, and it isn't mentioned. Do you think that that is of some concern about how open and transparent your firm intended to be with the Criminal Cases Review Commission?
I don't believe I gave that any thought at the time. It seems to me that I've simply forwarded documents.
Can we please look at Poll 0013970? So you were simply forwarding documents on the 16th of July relating to the Criminal Cases Review Commission. We're now a few days on, 19th of July. You're attending what is called a regular call regarding Horizon issues. Is this the first of those meetings?
I believe it was, yes.
And it then became a regular call relating to Horizon issues?
Yes, they were weekly to start with, and then at some point in the future they became fortnightly.
If we scroll down, please. Rob King, who's a member of the security team, says as follows, the note is as follows, no minutes circulated, but we will be taking notes. So it seems as though there is some sort of direction that no minutes from these meetings will be circulated. Is that something you recall?
Well, I've dealt with this in my witness statement. I recall that one of the civil lawyers from Bond Dickinson explained virtually straight away after Mr. King had spoken the reason for this, and he was clearly talking from a disclosure position in civil cases. He said that he'd had previous experience of this and that he was concerned that if minutes are circulated by email, they then can result in information being stored elsewhere away from the call. And so whilst he was concerned about that, I considered that from a criminal perspective. In London, at the meeting, Simon Clarke had been very careful to advise the legal department of Post Office what their obligations were and what their duties were from a criminal disclosure point of view, and that a central hub should be set up to collate information. And then I was equally concerned that we could be faced with a situation where there could be several mini hubs of information containing various amounts of information which might or might not be correct, and going forwards that would make a disclosure exercise very, very difficult, and also difficult to instruct a new expert if there are different hubs of information. So I understood the rationale for that.
Let's see where you're mentioned. If we scroll down, it has your name in the next box. And it says, confirmed it was good Horizon wasn't discussed at length during interviews under caution, and also the use of template statement. Would like to be appraised of developments regarding interviewing and to have sight of statements and scripts. And then it says this, it says, clarification on disclosure and email correspondence, emphasise need to ensure that any document produced would be potentially disclosable. So is that you there emphasising that any such document that was produced would be potentially disclosable?
Well, I don't think this is correct. I believe that I spoke towards the end of the call, not at the beginning. It was Mr. Parsons who spoke after Rob King. He was concerned about inaccurate information being generated, and when I spoke, I explained that any information generated obviously needed to be accurate and kept, because it may well be disclosable.
We see there are two entries from Mr. Parsons. The first one says as follows, commented on the need to limit public debate on the Horizon issue, as this may have a detrimental impact on future litigation. And if we scroll down over the page to page 3, near the bottom of page 3, the third entry from the bottom, we see another entry summarising something that he is said to have said, which is spoke about emails, written communications, etc. If it's produced, then it's available for disclosure. If it's not, then technically it isn't. What did you understand by that?
Well, I understood him to be talking about pre-action disclosure in civil cases, nothing to do with criminal litigation and criminal law. Post Office had already been advised from a criminal perspective quite thoroughly by Simon Clarke. They'd accepted that advice, they'd set up this call, and he was a civil lawyer on the call, clearly not offering criminal law advice because he's not a criminal lawyer, but clearly looking at the position from a civil law perspective. He spoke at the outset of the call about his experience in previous cases where he'd had nasty surprises when he'd done trawls of emails and found information that I think was incorrect or something like that. So clearly what he's saying there is basically a warning, because if people aren't committing things recklessly to paper, or if they're not recklessly writing emails, then it obviously makes his job easier.
What about the first one, page 2 in the middle, commented on need to limit public debate on the Horizon issues, as this may have a detrimental impact on future litigation? I mean, was the advice that was being given, if not by you, then by Mr. Parsons at this meeting, one of limiting what is said about Horizon issues?
I don't recall the meeting, and I generally made copious notes, which I left at Cartwright King. My understanding was that he was concerned about incorrect information being discovered on email trawls, then going into the public domain through pre-action disclosure. And of course, if people have been guessing or speculating or coming up with incorrect points, well, I guess his point was that's equally disclosable in a civil case and could cause damage to Post Office.
What's noted here, though, is much wider than that, isn't it?
It is need to limit public debate. I don't recall that.
And if we scroll up, the first page, Rob King, no minutes to be circulated. I mean, that must have been of concern, mustn't it?
Well, it would have been had Mr. Parsons then not explained his rationale for that.
I I mean, let's just look back at everything that we've discussed so far today. You were involved in the criminal prosecution on behalf of the Post Office in a number of cases,
yes.
correct? You've prosecuted people, resulting in some cases going to prison, certainly Mr. Ishak's, correct?
Yes.
Yes. Irrespective of your knowledge at the time you were prosecuting, you have by now found out that there was a lot more information about bugs, errors and defects in the Horizon system than you knew at the time. Is that right?
Well, at this point in time, we have knowledge of the Helen Rose report and the second site draft interim report.
Yes, and you've also learned about concerns that an expert witness who had been giving evidence in your prosecutions knew a lot more than had come out in evidence about bugs, errors and defects.
Yes.
You read the Helen Rose report by this stage, correct?
I believe so, yes.
You've been sent a draft response to the Criminal Cases Review Commission, which makes no mention of a number of those matters. Is that right?
Yes.
And now there seems to be a discussion about limiting the amount of information in the public domain. Does that not cause you real concern at this stage?
Well, no, it didn't, because Mr. Clark had advised that there be a central record, and as I understood it, a central record was going to be created. That was the purpose of this call, and quite frankly, I was content for there to be a single central record, not several central records.
But why no minutes circulated?
Well, as I say, that had already been explained, because people then can forward them on, and that could then attract other opinion, get forwarded on to others. And I think it was a sort of described as a sort of spider effect, where it can crawl and you don't know where the emails end up, and you don't know what's been added to them.
So is the purpose of the central store not to make sure that everybody had access to central material, but to keep everything away from being distributed?
Well, no, that's the purpose of the central store was to ensure that everything was collated in one place. That would be then interrogated for disclosure purposes, and it would also mean that instructing any new expert, there is only one single central store be sent to that expert. And as I understood this, if there were applications for pre-action disclosure, and I don't know that much about civil litigation, but again, there's a single central store for that. I think the point that we had in mind was that it would actually serve both camps if there is one single central store. The minute that you start having emails being circulated with people then being able to add to those email chains in a way that wasn't visible to the central store, the minute you start to not have full visibility of the issues which perhaps ought to be recorded in the central store. So at that point in time, I was not actually concerned about that.
Can we then look at document retention and destruction post 19th of July? And can we look at poll 00139.745, please? This is a discussion that took place on the 1st of August 2013. Is this your note?
Yes.
Yes.
My details are in the top right-hand corner, yes.
So it seems as though you had a telephone call with John Scott on the 31st of July 2013. Is that correct?
No, that's not correct.
When did you have a discussion with John Scott?
It wasn't a telephone call with John Scott. JS here would be John L. Singh. So this was a note that I made on electronic file 37142 on the 1st of August 2013 relating to a telephone call that had taken place at approximately 6 p.m. the night before the 31st of July. And as you'll see here, the summary cuts off, but there's more detail in the lower section. J. Scott has instructed that the typed minutes be scrapped. There was obviously a lot more to that call because, as you can see from the time recording at the bottom, I was engaged on that call for some 24 minutes.
It's a summary that's there. It's very important for this inquiry to know what you recall about that discussion and the words used. Can you assist us?
I think I've put this in my second, well, both witness statements, because I could see in my first witness statement this was something that was going to be of relevance. I was actually driving at the time when I took the call from Mr. Singh, and I can recall complaining to him about the influence being exerted over Post Office, in my view, by the civil lawyers, the external civil lawyers. And I can also recall him telling me that an instruction had been sent out, and that if anyone that the type minutes should be scrapped, and that if anyone asks, then Cartwright King would be blamed for providing that advice, or words to that effect. Another mobile telephone to record at a distance the latter part of the conversation, because I was just so shocked by what I'd heard. I can recall relaying that to Mr. Clark. I'm afraid I can't really recall much more about precisely what was said, but I remember that I relayed to Mr. Clark the concerns that Mr. Singh had, that I had, and the comments made. From memory, this was just after the third Wednesday morning call. So there'd been a space of about a fortnight since the first call. No minutes were being circulated. And I can remember saying to Mr. Singh, I can appreciate the reasons for that, and quite frankly, that actually wasn't necessarily a bad thing from a criminal law perspective if it meant that there was a single central store which was accurate. It made our life much easier to just go to one place rather than having to wonder if there was information in several places. The same approach was adopted on the second call, but I can recall by the third call there was some form of change proposed. I don't remember, I'm afraid, exactly what the change was, but I do remember saying on the call, no, hold on, you still have to keep a central record, and making the decision that I would ask Mr. Clark to prepare a formal advice to Post Office so that it put absolutely in black and white their obligations, and confirming effectively what he had told them at the very first meeting, the advice that they had accepted and acted upon to set up that Wednesday morning call. And I was actually concerned that Post Office had accepted that advice and acted upon it, but in my mind it was the actions of the civil lawyers that were now trying to water that down and move away from that situation. And I'm afraid I took the view that must have been the actions of the civil lawyers having an influence there, because Post Office had accepted the advice that Mr. Clark had given to set up that call, to have a central hub. I took the view that they'd accepted that advice and were acting in good faith to do that, and therefore formed the view, rightly or wrongly, that it must have been then the function of the civil lawyers, the effect of the civil lawyers, who were then trying to pull away from having that central hub. And I considered that by the time we got to the third Wednesday morning call,
first of all, did Jarnail Singh tell you that this was on legal advice, or did you not have that conversation? You've said a number of times it was the advice of the civil lawyers. Is that an assumption, or is that something you were told?
Sorry, that was the... no, I assumed when I was talking to Jarnail Singh that it was the advice of the civil lawyers to move away from having anything in writing. Because we'd gone from having a situation where minutes weren't going to be circulated, but a central record was going to be kept, notes were going to be kept. I was expecting some form of like minutes or a spreadsheet or something that would be documenting the issues arising in accordance with Simon Clarke's advice, which had been accepted. So the second meeting took place. Again, there was the same sort of discussion at the beginning, but by the time of the third call, it was a case of there being some suggestion that we're not going to do things in this.
Was it that notes or typed minutes were to be stopped, or were they to be destroyed?
To be destroyed.
And was that your clear understanding from that conversation?
Yes.
We know that in Mr. Clarke's advice, he uses the word shredded.
Yes.
Do you know where that came from?
I can only assume it's arising out of the conversation that I had with Mr. Singh.
And is that something you recall from your discussion with Mr. Singh?
Not at this point in time, no.
So you don't recall the specific word shredded, but you do recall that typed minutes were to be destroyed rather than there was going to be some sort of stop in taking future minutes.
No, that was very much my understanding, that Mr. Singh told me that the understanding that I had was that Mr. Singh told me that the minutes were to be destroyed. I can't remember the exact phraseology. I'm afraid
were
it's
to
10
be
years ago.
or had been. There's a big difference between the two.
I was under the impression that the instruction had gone out and that they had been.
Instruction from who to who?
The information that I was given that it was Mr. Scott, John Scott, head of security, who had sent that instruction out. To whom I believe it was I'm hesitant here because there were a number of people with the name David, and I'm thinking it was either David Pardo or David Posnett, but I'm afraid I can't. It was a long time ago.
And did you understand that Mr. Scott had received advice in respect of that matter, or that he was acting on his own instigation?
I had no idea. I was concerned by that third Wednesday morning call that somehow there was a plan to change things. I didn't like that. And then...
what was it that happened at that Wednesday meeting call that was of significance?
I was left with a distinct impression that Post Office were no longer wanting to keep a record of the calls. And I can recall saying, no, you must still keep a central record.
And
I don't know
say
if you have
Post Office, who at the Post Office?
I think that was information that came from Roderick Williams. I think it was Roderick Williams who said that, because I think I said, Roderick, you still need to keep a central record. And I remember not being very happy about it and thinking, this is one for Simon Clarke.
And civil lawyers were present at that meeting. Did they have any input as far as you were aware?
I don't recall, I'm afraid. And I don't have my notes from those meetings.
I might just take you to one more document before we finish for the day. Can we please look at poll 0013976? This is an email from Jarnail Singh to yourself on the 1st of August, so the morning after.
Yes.
And he says, Martin, I know Simon is advising on disclosure, so it seems as though during your conversation there was a discussion that Simon would be advising.
Yes, I've told him that clearly the disclosure situation in criminal law is very different to that in civil litigation. A central record needs to be written, needs to be kept, and that's the position.
And it says, as discussed, can he look into the common myth that emails, written communications, etc., meetings, if it is not produced, it's then available for disclosure. If it's not, then technically it isn't. Possibly true of civil cases, not criminal cases. Those words there seem to reflect the minute that we saw
yes.
Mr. Parsons, the words from him. What did you understand Mr. Singh's position to be, or what was he asking for here?
Well, I was a little puzzled when I received this because I'd already told him the previous night that we weren't getting involved in the civil litigation side of things, and whilst the civil lawyers may not want things in writing, it's the information that matters, and you have to have a central record.
And common myth?
Yeah. Well,
was that amongst the legal team or something else?
I have no idea where he got that from. Absolutely no idea. What I do know is that Mr. Parsons had been talking from a civil criminal law too, but I remember pointing out to him on that on that phone call the previous night that I was actually getting quite concerned because Simon Clark's advice had been accepted. It had been watered down slightly, but in a way that I could live with. And then, of course, there was now going to be a further change, which I was actually quite concerned about. And therefore, I was asking Simon to further advise.
Thank you. So that could be an appropriate time to stop. We've been going for a long time today.
Yeah, yes, indeed. So what's the programme tomorrow? We've got Mr. Ojar returning, yes?
We do. That should be for no more than an hour, I believe.
But is that happening first thing, or
yes.
is he good?
So that will happen
happening first thing
at 9:45, and then Mr. Smith will come.
Then continue.
On. Yes.
Yeah. All right. Fine. I'm sure, Mr. Smith, you know that you shouldn't discuss your evidence overnight, so please don't do that. And I'll see you in the morning, probably at around 10:45. And everyone else at 9:45. Thank you.
Thank you, sir.